Good morning.
Morning.
Hello. We are going to get started. Today is Monday, August the 8th. This is the complaint committee meeting for the Cosmetology and Barber Examiners Board. And we have Chair Ron Gillihan substituting today. Mr. Frank Gambuza was not able to make it, and I'm not sure if Mr. Fingers will be able to join us later or not, but we do have two board members, and then including Ms. Amy Tansley, so we will be able to proceed. And I'm going to turn it over to Laura on your iPads. If you will please open the legal report.
Good morning.
Morning.
So I had a couple of cases on the legal report where my recommendation was just that we discuss it. I don't know if you happen to notice that, so I thought we could start with those, and then if you had any cases after that, we could move on to those, if that's okay.
Sure.
Okay. So the first case that and goes through to page 7. Report like this, so and this is sort of new, but what I'm seeing is that there's a new business model where, so for instance, this one, a complaint was filed against the respondent for unlicensed activity. The respondent company advertises to throw Pamper the Princess birthday parties for little girls. The parties include hair and makeup being done on little girls. They dress up, they have a photo booth, they set up a runway. The pictures are adorable. They also set up tables where they do crafts. So they're not licensed though. They're not licensed cosmetologists, and both companies, in response to being informed that there was a complaint open against them, said that they're not doing hair and makeup for anything other than the pageantry of it. And I think that's very ambiguous. That's very great. I didn't even put a recommendation because that is just so new that I thought we should discuss it. So we can discuss it here, or we can discuss it at the main meeting. The other case that was like that, I want to read both of them in, and then obviously our decisions should be consistent. So on case 43, which is page 14,
On page 13 of your iPads, yes. Case 43.
is it the same?
Just
It was about the underage
It's
young.
a different, that we need to discuss that one, but that's not the same business, I'm sorry. Okay, case 57 on page 18, I apologize.
They're also
This was an
doing
anonymous
these-
complaint. It was filed alleging that the respondent's shop has unlicensed and underage employees. So this is a licensed cosmetology shop, but they have 2 high school girls that they hire, and these high school girls, they do the same thing. They throw birthday parties for, the 6, 7, 8-year-old girls, and it's, so the person that owns the company is licensed, but I guess the company owner she clearly doesn't see this to be the same as when she's cutting hair and doing skincare for her customers. This is a totally separate part where it's for these young girls, and they dress up, they do hair, they do makeup, they have photo booths, runways, crafts, and again, the same thing is this is for pageantry, this is for photos only. She said that she does have licensed cosmetologists supervising, and that the girls who are unlicensed that work for her are mostly setting up, but the complaint filed alleged that they're also painting nails and all of that stuff for these young girls. So I wanted to bring this issue up, and we can decide whether or not we think this is unlicensed practice or not.
Not quite the same as doing makeup applications in a department store, because that's a retail demonstration for those purposes, at those clinique counter type things that we talk about all the time. All's clear. You should not be working on the public for pay or for not. You should not be doing any of the services that are regulated by us. think that the owner of the shop in this particular case probably has an idea that because they're just doing these as little girl birthday parties and pageant type stuff, that's probably okay. But I think even under our rules, if someone is out doing work like that for a wedding or for pageants, they still need to be licensed.
Well, I mean, it's interesting because here in Nashville, there was a retail location that was doing this for years and was very successful, but they closed last year. And so it's interesting that the demand is still there, but no one has opened. But it was in a salon, a licensed salon, and they had all this specifically for birthday parties. So now I think it's interesting to bring it up, Ron, to the greater board, and I agree with you that anything that's going into homes, we probably need to talk about it because that's such the way things are going in terms of who's able to do what.
Well, the difference between case 57 and case 17 is that in 57, there is a licensed cosmetologist overseeing this. And I mean, her argument is that she's the one that's doing the services. The complaint did allege something totally different. So I think here, if a licensed cosmetologist is offering the services and they're specifically doing it for the purpose of photo shoots, the runway, the pageantry of it, I think that here, potentially, as long as she's the only one giving the services, that they're okay. Little girls are coming in and making hair appointments. It's definitely just who's ever. So I think with them.
The question for you, if the shampoo license is 200 hours?
300.
300 hours. And that's the lowest houred license currently, correct? So would that allow them to do these styling? Does that allow for styling?
No, just strictly shampooing. If they were to decide to go down that venture and do these parties, and it would still only let them do the shampooing.
The recommendation would they would need to be fully licensed.
Nails, they're curling hair, they're putting on makeup, they're doing it all.
Yeah.
Knows. The difference with 17 though is nobody's licensed. This
Right.
is clearly just a birthday party business.
You know, in the case of the licensee, if she's doing the work, then she's perfectly okay to do that. The person who's licensed is fine.
They take it outside of the home. That was I think it's okay if they're taking it outside of the home. If we go by the theory that this is for the photos and for the pageantry for the birthday party, then it's okay for them to be working outside of a licensed shop. But if we think that it doesn't fall into that category, then that's the second part we have to look at.
What do we do if they're doing a photo shoot for a music video or something like that? What's the rule?
That falls into like entertainment services. So as long as the person is licensed and they're on like a photo shoot set or a movie set, then they don't have to have a shop license.
You see where I'm going with that? I kind of see those as being similar, but maybe a
I
little
tend to
different.
think this does fall into that. Okay. So I think that for 57, after hearing I would recommend maybe a letter of caution or a letter of instruction. I don't think they're doing anything wrong, but the complaint does allege that the unlicensed people are taking part in the nail painting and all of that. But maybe just a letter of instruction or caution explaining that all of this is fine, a reminder of the exception in the law, and a reminder that anyone unlicensed can work for you for the ancillary stuff, but they can't be providing any services. And then for 17, I'm assuming.
And I would recommend just to be very detailed. Nail services, hair services, makeup services. I mean, the good news is there are lots of licensed cosmetologists that she can hire.
And then for case 17, where they're just totally unlicensed. What would you think is an appropriate response, or
Do we have any complaints on this one before?
no?
I would go for a clear letter of warning explaining what the rules are and aren't. And then if it's violated again,
Very reasonable.
I do think there's some misconceptions about what qualifies as needing a licensed.
So on 17, there's no civil penalty that you're recommending?
Not in this case.
Okay.
We're sending the letter in 17.
Yeah. So for both of them, just to
Yes.
clearly say, hey, this is the law and this is not the law and this is how you can be in good standing. I would think that they wouldn't have that much trouble hiring. What a wonderful thing to do.
I think the barber technician license actually allows you to do a little more than just the shampoo.
300 hours too? It's
Yes, it
340.
does. You're absolutely right. It lets you do more.
Yeah.
Okay,
So,
interesting.
there you go.
Okay. If we can move on to case 43, that's on page 14 of your legal report. So this is a represented case. You'll remember we had last meeting and we have more this meeting with the Texas licensing issue. So this is a represent because this respondent has sent in quite a bit of information showing that she did in fact live in Texas. And the problem that I have with this case, with us going forward on this case, is the order is written. The order set the schools, okay, the consent orders from Texas are against the schools. The schools admitted to giving students hours while the students actually lived in Tennessee, even though the students lived in Texas. So the fact that, so the school is admitting to giving away fraudulent hours, but for the individuals named in each order, the fraudulent nature is sort of wrapped up in the fact that they were able to place them as living in Tennessee. And you can't, I mean, so this woman sent in quite a bit of good information showing that she did live in Texas, at least until right up before she had allegedly attended school. And then she does now live in Tennessee, but neither the state of Texas nor my department can place her in Tennessee until at least a year after she allegedly finished going to school. So I can definitely place her in Texas sort of like up to a certain point, and then there's a gap where we can't place her anywhere, and then it's only much later that we can prove she was living in Tennessee. So I kind of want to discuss this because there's so many cases that are going to come out of this whole ordeal, but I'm not so sure that we could go forward to a formal hearing with this case and
Against her, because there's no proof of where she did or did not live.
well, the order says she never lived in Texas, and that she's kind of proven that to not be true. So I'm not so sure that we have enough to go against her, because the school admitting to giving her fraudulent hours, it's very much wrapped up in them not actually living in the state at the time they went to school. So
On the consent order, she's actually perjured herself. If she's saying that she was but wasn't, is there some kind of an integrity thing going on there?
no consent order.
She hasn't
Signed it. The signee, the person that signed the consent order in all of these cases in Texas, the school. So what Texas did is they sent us the consent orders, and then the students that the school admits to giving fraudulent hours to are named in the orders. I'm not entirely sure why Texas didn't then go after the individuals. I don't know why, but we have, because we gave reciprocity to all these
Right.
people based on the fact that they said they went to these schools in Texas. With this person though, being able to prove that she did live in Texas, at least right up until she went to school, I think makes this a much more complicated case.
We have several of these, correct?
Right now, she's the only one who has sent me any documentation that would really, that mitigates the consent order at all. Most people haven't responded. Some have responded, but were unable to send me anything that I think is worth bringing back to the board. But I imagine more will come forward, because we still, I think we have 7 on this legal report, and they're still coming.
I've finished the whole round of these Texas schools revocations, so the board with these will have all of them, and one is going
on this
before.
report's the last bunch?
I think so.
Okay.
I think so. And the board is hearing from one that is going to surrender his license as long as the board will let him start testing. So that may end up happening with some of them, because some of them, I believe, did have legitimate hours even here. That's his case. It was easier to test in Vietnamese at that time in Texas.
I hear what you're saying. I mean, this person has provided proof of living in Texas. We can't say that she doesn't. I would think that for any of these folks who have lost their license, if they send in similar documentation that is approved, I don't know that we have another choice.
I think I have to agree with you. The only other thing that I could think of is hesitate, because it would create a really difficult process for some of them, would be on a case-by-case basis, have them come in front of the board and explain their case, tell us. There's only so much I know that we can get in correspondence sometimes, and it's much easier to judge somebody's.
There are times when there are complaints open against respondents and they do request to come in front of the board. But then the board can't actually make a decision, because it's, well, that kind of creates a problem. I think in cases where somebody, like Roxana was talking about, the person that's coming today, they're coming before the board to ask to retest. So that makes it slightly different.
It's their choice.
It's their choice. But yeah, when it's just a case and it hasn't been transferred to litigation or anything like that, I have a hard time figuring out how somebody could come before the board without making it so that nobody who actually heard what they had to say would then be conflicted out.
Outside of that, I agree with Amy, I think.
Okay.
So if folks come forward and they have legitimate documentation that they were in Texas while they were in school, as far as you can tell, we move forward?
I think so. I don't think we have enough to go against them.
What Laura stated was, if they have, and in her case, it's not 100% proof that she lived in Texas. It's enough doubt because we can't put her in Tennessee. In some of these cases, folks live with families. They'll go state to state, and they have 3, 4 licenses
Okay.
because they're living with families.
So I have messed up a little bit. I've been talking about a different case. Case 43, she actually didn't offer me any proof. She just said she moved to Texas so she could take the test in her language. I contacted her and asked her if she could offer me proof, much like the case we've been talking about, which is on the legal report. I just want to, for the record, make clear that the case we've been talking about is case 78. Case 78 is the one where she actually sent me quite a bit of information. She showed me an immigration letter addressed to her at a Texas address, a letter from the Social Security Administration addressed to her at the Texas address, a temporary driver's permit, and a letter from the Texas Department of Licensing and Regulation addressed to her at a Texas address. I've been talking about case 78 this whole time, so I apologize. I'm totally
Rewind, back
messed
up.
you up.
There were a couple, but I agree with you, Laura, that in this instance, she's provided the proof.
Okay.
In the previous case, and I think there were 1 or 2, and you said there was no proof.
There's no proof. They're saying the same thing that she did.
Right,
She's
but there's no
saying
paperwork.
There's no paperwork
And you've got to have the
document
paperwork.
it.
I agree.
So I think in the ones where there was no
And if you've
paperwork.
lived somewhere for any length of time, there's something.
So, I think then for case 43, we should go forward with the revocation like we are with the rest. And then for case 78, I'm gonna recommend that we close it. Okay. I'm sorry about that mess up.
I just want to be consistent. I mean, I have
I-
a feeling that, this won't be the last time we talk about something like this, so.
Okay, I believe that was all the cases that I had specifically marked out as needing discussion. To talk about, we can move on to that.
I had a few notes. Ron, I know you're probably going through this quickly. Thank you for helping out. And Bobby, good morning. My question started on case 7, and there were a few of them like this, but I just wanted, again, for consistency's sake, this was for expired licenses. I just wanted to understand that if the owner of the shop, if the shop license is expired and the personal license is also expired, there are instances where you've assessed a $200 fine for $100 per license, and there are other instances where only $100 is being assessed.
So, for instance, on case 7, she was cited on both of her licenses, because one is a shop license and one is her license, but at the time of inspection, only the shop license was expired.
Oh, okay, I see. Her personal license was not. Okay, so that's why it was 100. That makes sense. It was also cases 48 and 49. Maybe I misread them, I'm sorry.
No, I clearly have already made multiple mistakes.
15 and 16.
So case, 49, 48, 49, shop license and personal license.
So I can change that to 200.
And then same thing on 50 and 51. And again, it's, for me, it was just consistency to say, is it $100 per license or when
they just have one license expired, but they're cited on both of them, I've been going with 100. I should have put 200, and I must have just been moving too fast.
That's all good. Case 15 was for unlicensed activity. I had a question of whether the shop was licensed. Yes.
No. Well, hold on.
I know that the respondent was given a pedicure and is unlicensed. I wasn't sure whether it was an actual.
This was the only
Shop.
case that was sent to me. Usually in these scenarios, what happens is the shop settles by agreed citation. But this was the only case that, the shop that they were working in, I assume was licensed, because
Okay.
they've already received an agreed citation and settled it. And they wouldn't get an agreed citation if they were completely unlicensed. This person is completely unlicensed, so that's why this is coming.
Okay. Thank you. And then my last question was on 40, well, no, I guess two more, I'm sorry. 46. I was just curious to where you got the 500.
So, they've already sent in $150 to the agreed citation, so they signed the agreed citation, and I think that the 500 is for not having a manager present, and then the 150 was for the expired license and the sanitation. And because they had already sent in money, I was trying to just, I was just trying to come up with something to like go with that, so.
Okay.
We can go, if we went to $600, that would be $750, or 500 is $650. So it just depends on the violations here, what you think is appropriate. But I was trying to subtract the 150 from what we assessed them since they had already sent that in.
Okay, that makes sense. No, I wasn't advocating that it be any higher. I was just curious what the math looked like there. I'm getting used to these standardized fines. I don't have them all memorized yet.
And I try to be consistent in my recommendations, but I do consider mitigating factors. So sometimes you'll see ones that are different, and I try to put in my description if I think it's a
You do a great job.
I noticed in 47, we have some folks running out a back door again.
Yeah, that was my last one. That was okay. No. Yeah, these folks, not their first rodeo.
This person owns 3 shops, and all of them have been cited so many times for unlicensed activity. I think he has total 8 open complaints right now against him and his. He has 6 cases or 8 cases, I think, in litigation that are set for a hearing. Actually, what I'd kind of like to do is add to my recommendation, now that I bring it up, is I would like to send all of the cases against him to litigation for revocation, and then once, if there is revocation achieved through a formal hearing, I'd like to go ahead and just have permission to administratively close any additional complaints open against him. There's so many complaints against him that we'll think we finally have them all, but the inspectors keep going to his shops because they keep having unlicensed people, and since there's 3 of them, like, a new one comes in. So, yeah,
So we're going to go for revocation for all of the shops?
I think so.
I think he's demonstrated a willingness to not comply.
So I'm gonna change this to revocation, and then I'm gonna ask that once revocation is achieved by any of the complaints opened against him, that we administratively close the ones that are still left. Otherwise, I would just present them to you, say, they've been revoked, can I close them?
Thank you. Yeah, I mean, I really like the comment about, you've already been here to inspect.
Oh, yeah. I mean, I've talked to them, they wanna know why they keep getting inspected, and I said, well, because every time you're inspected, you have unlicensed activity. The inspectors almost always, like, check back in. You're going to be inspected more frequently if you continually have unlicensed activity. I'm rather contentious.
56 was very unique, so I think that's very appropriate.
Yeah, that caught my attention.
Oh, yes, 52 through 56. A Vice Sting in Murfreesboro. I have spoken with the attorney over the massage board. They also are, because these are all dual licensed shops for massage and cosmetology. And there was prostitution in all of them. So I'm assessing revocation for all the shops involved and all the individuals involved.
They closed, I believe, all of them soon after the incident. We sent an inspector to make sure that a summary suspension wasn't in order
Gotcha.
prior to, and we knew the board meeting was soon enough. So the fact that they closed their doors, gone down that path to make sure to protect the public.
That's all I had. Thank you very much.
Okay.
On number 68, if not, this is probably the last one that I had noticed. In this case, there was a barber student working in that one. What action would be taken with the student? Oh, I see it right here. I'm sorry. I see it on the bottom.
I'm 2,500 against the shop and then 500 against the student. With the students, I do have a hard Unlicensed activity, definitely. I do sometimes wonder if we want to charge, if we can. I find it to be a little different, which is why sometimes I recommend a lower penalty. That's totally your choice.
It's normally 1,000.
I mean, we're talking about a guy who has gone to school. He just hasn't, he's clearly been working the whole time he was in school. I can't prove that, but that's the impression I got from his response.
Pass the theory exam. And
He
there's
has
an
not
absolute,
taken,
there's an absolute law portion on that.
well, yeah.
The concept that they don't know, didn't know, couldn't know.
And he definitely, in his response, does not claim ignorance of the law. He doesn't at all. He claims to have been in like financial struggle and did this even though he wasn't licensed, and has like asked for a consideration of the fact that he has gone to school and that he did do this because he was in financial, really tough financial spot. I don't think that that's enough to waive it, but it was enough for me to consider maybe a lower penalty.
Bobby, do you have a opinion on that?
Nothing.
I think your recommendation will be fine.
All right, yeah. I mean, I do agree that hitting the shop up hopefully will prevent shops from employing unlicensed folks.
On the students, anytime that we are able to get their real identity, then when they come back for the license, as the board has seen, we have them come before the board and ask for that license, so it doesn't go right back, right out. If there's anything else, we will make sure to wrap up. The Reciprocity Committee has a full load today, so anything, no, we're good? Okay, Laura?
Okay. At the full meeting, we'll just ask them to adopt it with the amendments that were made.
I think we want to talk about the princess
Okay.
pampering. I could use some of that, but
Thank you very much.
Thank
So
you.
that'll conclude the Legal Complaint Committee, and we will stop for about 2 minutes. Thank you.
Ron, thank you.
Good morning.
Hello.
Okay.
We got a busy one.
Today is Monday, August the 8th, and we are starting with the Reciprocity Committee meeting. If everyone make sure, open your iPads.
Roxana, her microphone's not working.
Oh,
Maybe.
nothing. Can I get you to relocate? Yeah, today we have Mr. Gambusas out, as well as Anita Allen, either one. And we'll report that. Thank you, Patricia, I'm so sorry.
Yeah, this one's working.
Okay, first we have an applicant for reciprocity of a master barber license. And this is from Michigan for Allah Al-Hashimi. Certification shows an initial licensure in December of 2015 by Reciprocity from Iraq. Mr. Al-Hashimi has provided translated certificates, a transcript showing 2,600 hours, received between 2011 and 2012. My recommendation is that he take the Tennessee examinations.
Is reciprocity be coming from Michigan?
That is correct, and if you'll remember, Michigan allows international information, and they do put them through exams to be consistent. We have asked them to take the exams as well, unless they've been working in Michigan for 5 years or in the United States. We've had some situations we've had to represent because of the language, but that's how we've been recommending.
Make a motion for him to take the Tennessee exam.
Second.
Motion and a second that he take both Tennessee exams. All in favor?
Aye.
Motion carries.
Application for reciprocity with education obtained in Mexico in cosmetology for Evangelia Arcos. Various documents were provided for the board office, including certificates and diplomas. Translated educational form shows she completed 1,600 hours in November of 1998. The recommendation is that she take the Tennessee examinations.
Her application is marked for manicurist. Is that all?
No, it's for cosmetology.
I'm sorry, I
No, that's
went
okay.
too far.
Always question me.
Where did she get her hours?
Mexico.
Oh, okay, so that's why you're recommending both
Yes,
exams?
that's correct, yes.
Okay.
Make that motion.
Motion and a second that she take both Tennessee exams. All in favor? Aye. Motion carries.
Application for reciprocity of a manicurist license from Florida for Amy Brewster. Certification shows an initial licensure in September of 2002 with 240 hours and no examination. Ms. Brewster has provided a notarized letter from an employer stating she was employed between 2003 and 2013. She does not have proof of work history for the last 2 years. The recommendation is that she take the Tennessee examination.
Take the Tennessee exams.
Second. Motion and a second that she take both Tennessee exams. All in favor?
Aye.
Motion carries.
Application for reciprocity of a cosmetology license from Florida for Paige Danielle. The certification shows an initial licensure in August of 2011 with 1,200 hours and no practical exam. Ms. Danielle has provided a notarized letter from an employer stating that she was employed there between August 2011 and 2014. She's also provided tax records, so even though she doesn't 100% meet the 5 continuous years, she does have work experience. My recommendation is that she still take the practical exam.
That's the one she's missing, correct?
Correct.
Make a motion for her to take the practical.
Second.
Motion and a second that she take the practical exam. All in favor? Aye. Motion carries.
Application for reciprocity with education obtained in the Republic of Guinea in African braids for Kidaitu Diallo. Ms. Diallo did not select the license type she's pursuing, but the closest license we would have to that is a natural hairstyling license. She provided translated documents showing that between 2003 and 2006, she completed 300 hours. My recommendation is that she take the Tennessee examinations in natural hairstyling.
Motion for her to take the exam for natural hairstyling.
Second.
Motion and a second that she take both Tennessee exams in natural hairstyling. All in favor? Aye. Motion carries.
Application for reciprocity of an aesthetics license from Florida for Robin Erb. Certification shows an initial licensure in December 1990 with 500 hours for the full specialist license with no proof of examination. Ms. Erb has provided documents regarding her work experience in Florida and in Massachusetts. She is requesting that the board waive her need for the examination since she has been in the industry for 25 years. My recommendation is that we approve her for reciprocity. On your iPads on page 20 is my correspondence through email with her. She was unable to appear before the board.
She wanting the esthetician?
One in the esthetician, that full-service license in
Right.
Florida is the 240 is manicuring, 260 is the aesthetics. However, her letter from her employer, well, the fact that she's licensed in 2 states, and then her letter from the employer, let me see, where is it? No, we've got tax records for her for all of the years, and then her statement requesting that she not take the exams. What we've done is the board hasn't set a timeline of when I would be approved. You wanted to always see them on a case-by-case basis, but she's been working for over 25 years.
As an esthetician?
Yes.
Okay.
Make a motion to grant her the reciprocity.
Second.
Motion and a second that we grant reciprocity. All in favor?
Aye.
Motion carries.
Application for reciprocity of a cosmetology license from Florida for Marcy Ginsburg. The certification shows initial licensure in October 1996 with 1,200 hours and no practical exam. Ms. Ginsburg has provided a notarized statement that she has worked experience in Florida since 1996 through 2015. Her tax records for 2014 and 15 show a shop with an address of Tennessee, but upon further investigating, the shop's physical address actually is in Florida. She is requesting that the board waive the examination since she has been working in the industry for 20 years. So she too has plenty of work experience. I questioned the tax forms, and actually Michael, that's here with me today, kind of learning the whole process, looked into it. The shop's physical address is Florida. She works between states, and from talking to her, seems to be kind of hired to do those kind of things. So
Recommendation is for reciprocity.
that is correct.
I'll make a motion for reciprocity.
Second.
Motion and a second that we grant reciprocity. All in favor? Aye. Motion carries.
Application for reciprocity of a cosmetology license from Michigan for Nala Gunber. Certification shows initial licensure in July 2013 by reciprocity from Iraq. Ms. Gunber did not provide any additional educational documents, but Michigan would always review those prior to approve them for reciprocity. My recommendation is that she take the Tennessee exams.
Cosmetology.
Pretty much identical to
Other ones.
some other ones we have.
Yeah. I move that she take the exams.
Second.
Motion and a second that she take both Tennessee exams. All in favor?
Aye.
Motion carries.
Application for reciprocity with education obtained in Mexico in cosmetology for Cruz Huerta. Various documents were provided to the board office, including certificates and diplomas. The translated educational certificate shows she completed 2,000 hours in 2010. The recommendations that she take the Tennessee examinations.
She didn't mark her application either for cosmetology.
No, she did not. I had to actually kind of read through what it was and what her hours are in to determine that it would be full cosmetology. Page 38 is the translated transcript, if you will.
The recommendation was for the,
That she take both Tennessee
Yes.
exams, yes.
make that motion.
Second.
Motion and a second that she take both Tennessee exams. All in favor?
Aye.
Motion carries.
Application for reciprocity of a manicures license from Florida for Linda Johnson. Certification shows an initial licensure in August 1991 with 240 hours and no examination. Pardon me. Ms. Johnson provided documents proving work experience in Florida. She is requesting the board waive her need for the examination since she's been working in the industry for 25 years. My recommendation is that we approve her for reciprocity.
You have proof that she had worked for
I
25
do. She's
years?
got her tax record. She has everything. I just, because of the size of the meeting, I didn't put tax records unless they were really relevant
Okay.
or skipped a year.
Right.
She had everything. What's in question here is the exams that Florida doesn't give, but she's got the 25 years' experience. So she's asking on her email for us to waive that.
Make a motion for reciprocity.
Second.
Motion and a second that we grant reciprocity. All in favor?
Aye.
Motion carries.
Application for reciprocity of a manicures license from Georgia for Nang Thai Mei. Certification shows initial licensure in November 2013 with 1,050 apprentice hours, which in Georgia is recognized as the 525 credit hours. Ms. May provided a document supporting her work experience, but she has been licensed, she has not quite been licensed long enough for the 5 years, and she's only missing the 75 hours. My recommendation is that we have her take the Tennessee exam.
That's about what we've been doing in the past.
I think so, that Georgia's at a tough state. They've got 2 or 3 schools that do the full 600 hours. So many of them end up going there because it opens up so many other avenues. When they don't, they're short the 75 hours, and none of the schools will just do that little. So they're in a tough situation. They've actually taken the exams in Georgia, so if the board's comfortable approving them, I have no problem. That's all she's missing. She's just about got the 5 years. She's short on the 5 years is the issue.
I'm licensed in Georgia as well, but I think I'd still like,
A motion?
Second.
Motion and a second that she take both Tennessee exams. All in favor?
Aye.
Motion carries.
Application for reciprocity of an esthetician license from Florida for Angela Moran. Certification shows initial licensure in March 2002 with 500 hours for the full specialist license and no examination. Ms. Moran completed her hours in 1995, and the transcript provided shows 602 hours obtained in aesthetics. She has also provided a signed letter from a plastic surgery office stating that she worked there for the last 5 years. My recommendation is that she take the Tennessee examinations.
Make a motion for her to take the exams.
Motion and a second that she take both Tennessee exams. All in favor?
Aye.
Motion carries.
Application for reciprocity of a manicurist license from Georgia for Lak Hu Nguyen. Certification shows initial licensure in November 2013 with 525 hours by examination. Mr. Nguyen provided most of his tax returns, but is only licensed for 3 years. He has a profit and loss statement, and this is on page 55, which also shows proof of working in the industry. He is short the 75 hours. My recommendation is that he take the Tennessee examination.
Make a motion for her to take the exams.
I have a question on the affidavit here on the front of this. There's a handwritten note. Look at the,
Which page is that on, Mr. Callahan?
51.
Oh, at the bottom?
page 50, and then there's a different different.
I don't, it isn't
Probably
from
had
the
somebody help
office.
him.
It's either his or somebody else. Yes, so he skipped some of the tax records. The profit and loss obviously shows he owns a business, but he's still short on the 5 years. And we're back to the same dilemma. It's only 75 hours we'd be sending him to school for.
From take both of the state boards.
Second.
A motion and a second that he take both exams. All in favor? Motion carries.
Next application is for reciprocity of manicurist license from Pennsylvania for Tina Nguyen. Ms. Nguyen actually came in person for the board meeting, so if the board has any questions, she is here. The certification shows initial licensure in May 2008 by examination with 200 hours. Ms. Nguyen is also licensed in Ohio since 2008, and there, of course, they are bumped up to managing manicurist license. She's provided several letters from employers showing proof of work experience. It's not the full 5 years, but it also shows that she was under an apprenticeship program in Maryland, but never got a chance to get licensed because she moved to Tennessee. My recommendation is that we approve her for reciprocity.
So she's had both exams.
Pennsylvania has both exams, yes. What it is very low on for the manicuring is the hours, it's 200. New York, or not New York, I'm sorry. Ohio is the other state that she's licensed in, and Ohio actually has the exams and the higher hours. And then to become managing means you actually have a shop and they bump you up to a managing cosmetologist or managing manicurist.
That's a different license.
It's a little bit higher than
Okay.
the manicurist,
Okay.
yes.
All right.
So my reason for the recommendation is that she's licensed in 2 states, started an apprenticeship program in Maryland, but they don't track it enough to be able to send us anything. So she's here in case the board has any questions. She's got various letters of recommendation that looked great. It didn't meet the entire back-to-back 5 years, but they pretty much show full working always in the industry.
I think she's probably demonstrated her skills since she's got the additional bump up in that license, so maybe we give her reciprocity.
Second.
Motion and a second that we grant reciprocity. All in favor?
Aye.
Motion carries.
Congratulations. Thank you for coming
You're
in.
welcome. Thanks for coming.
Good luck.
We're not always that easy.
Thank you.
Miss Angela Moran is here. She would like to speak before the board. I'm not sure what page she's on, so if we can take a break and go backwards for a minute.
Would you come up to the podium,
Yeah.
please?
Give me a minute, I'll look at what they say.
Here. Good morning.
Good morning.
Do we know what page we're on?
I'm looking for that right now.
Oh, here we
It would be
go.
Not long ago.
45,
Okay.
I think. Yeah. Okay. And so what did we decide on?
So we voted on this, that she take the Tennessee examinations. This would be because she's only been licensed since 2002, was my reason for the recommendation, to be consistent. The board usually has not waived the exams for anyone from Florida with less than 15 to 20 years. But I'm thrilled she's here. I did not know that she was, so if you've got any questions.
I've actually been licensed for 21 years. There was a 2-year gap where I moved with my husband who was in the military. I had a baby, but then I came back to Florida, and that's when the 2002 started. So I relicensed in 2002 with no problem. I've been working for 21 years as an esthetician.
And that license was always from Florida? Okay.
Yes, sorry.
So you're actually just asking us to reconsider that because you were out for military? Your husband was in the military? You moved?
Yes. It was just 2 years that I didn't relicense because we moved to a state where it was just really complicated to get the Florida to Texas license. So I decided just to stay home with my daughter, but then we moved back to Florida and I immediately relicensed in Florida.
And Florida is one of those states that if you have that gap, when they start you over, you lose the seniority on those years. So that's the reason her certification on page 47 says 2002. That's the only date that I can confirm. So, yeah, I mean.
And also in the state of Florida, even though we don't sit for an exam, we do take 16 credit hours every 2 years. So I do have to take a test every 2 years to relicense as well.
To take a test?
Yes.
Yeah.
Your request for, was for esthetician, not full COSMO?
Yes, please.
The board voted to have her take both exams. If we need to revote, that's perfectly good. I'll go back to our notes. If you change.
I think with her experience,
Reconsider this
yeah, she
and-
has her continuing ed and everything in 21 years. I would vote to.
Move that we
Reciprocity.
reconsider and grant her reciprocity.
Second.
Okay, motion and a second that we grant reciprocity. All in favor? Aye. Motion carries.
Thank you.
Thank you for
Thank you
coming
very
in. Sometimes hearing the whole
Oh, yeah.
story
Difference.
really makes a difference.
Thank you.
Thank you.
We know which one that was?
Which one it was?
Yeah, like
It's page 40,
number, I just keep a track, I know, never mind. I just keep track
Okay.
of how many we've
How
gone
many?
through.
Yeah, because we had her as one to test. Okay. Next, we are on reciprocity from Florida for Nina Calhoun Patton. Give me a minute and I will,
67.
thank you. It needed a minute. All right. This is an application for reciprocity of a cosmetology license from Florida. Certification shows an initial licensure in April 1992 with 1,200 hours and no practical examination. Ms. Calhoun Patton provided educational documents and a letter concerning her stating that she's been working since 1999 through 2015. She is requesting that the board waive her need for a practical exam since she's been working in the industry for over 20 years.
She had all her tax records.
She has provided tax records, yes, and proof of work experience in the form of a letter as well.
up for reciprocity.
Second.
Is that your recommendation?
Yes, I'm sorry, my recommendation is that we approve reciprocity.
Motion and a second that we grant reciprocity. All in favor?
Aye.
Motion carries.
Next, we have an application for reciprocity with education obtained in Mexico in cosmetology for Maria Isabel Pena. Various documents were provided to the board, including certificates and diplomas. The translated educational form shows she completed 1,520 hours in June of 2000. Ms. Pena will provide additional documents to clarify her name. We've got various forms of her name showing, so we'll need to review that before we proceed with her application. But otherwise, her education shows that she completed those hours in the cosmetology curriculum. My recommendation is that the applicant take the Tennessee exams.
Make the motion, she takes the exams.
Second.
Motion and a second that she take both Tennessee exams. All in favor?
Aye.
Motion carries.
Application for reciprocity of a manicurist license from California for Elise Pham. Certification shows initial licensure in April of 2003 by examination with 400 hours. Ms. Pham was asked to provide work history for the last 5 years, and she submitted 2010 through 2015. Her records were missing 2011 and 2012. The following request generated an email from the shop and from a shop in San Diego. The board office looked into the shop as well as the phone number. The address could not be confirmed as a shop. The phone number turns out to be a number to an individual. None of this information is accurate. Therefore, I'll leave it up to the board to decide. Obviously, in California, she would have taken the exams. I think in the search for those tax records, incorrect information was given to us.
Move to deny.
Second.
Motion and a second to deny request. All in favor? Aye. Motion carries.
If I could go back to her, so we can deny the application since she would be in essence missing hours for the 5 years. Do we say that she's missing the 200 hours and that's what she would need to complete unless she provides something else?
Yes.
Okay. Thank you.
I think that needs to come before the board again, if she does, because she's given false information.
Correct. Okay.
You have documentation of those hours that she does have?
Yes, we do. We do. That's part of the California certification. Their manicure hours are only 400. And so she's got plenty of years prior to the 2011-12. So I don't know. We called and said when we tried to confirm the phone number in the shop, this is all incorrect. And of course, the conversation ended there.
All right.
Next, we have an application for reciprocity of an esthetician license from New York for Suzanne Price. Ms. Price is here today. The certification shows an initial licensure in February 2013 by examination with 600 hours. She has submitted a copy of her bachelor's program information, also 2 additional certificates showing additional education in the aesthetics industry, including the medical side. My recommendation is that we approve her for reciprocity.
How many years of experience?
Since 2013. So the years of experience is not there. She's only missing the 150 hours, and we struggle with some of those aesthetics programs being able to fill those hours. But basically, based on the education, if you look at, you've got her resume and breakdown of her experience on page 85. Again, she's here if you would like her to answer any questions. But her certificate on page 86 on facial aesthetics and osteopathy. Then she's got something else from the International Dermal Institute, and then the bachelor's degree is on page 88. Although the work experience and number of years isn't there, I think the additional education she's done.
And she's already had a practical and a written exam.
New York does both, yes. New York just doesn't have the same number of hours we do.
Ms. Price, could you come up to the podium, if you don't mind, please?
Morning.
Thank you for coming in today. Maybe just a couple of quick questions for you. Can you tell me about this London College of Osteopathy?
It's a course in osteopathy and facial aesthetics. So osteopathy is, we think of medical science, and osteopathy is on the other end of the spectrum. And it, it's healing the body through structural integration, or hands-on, like moving fluids to create harmony
Is
in the
this
body.
college, is this an accredited school?
It's an accredited school. It's not in London. It's called the London School, but it's in Ontario, Canada. So it's one of the it's a highly regarded institution for studying osteopathy. So it wasn't just osteopathy and facial aesthetics. It was also for the whole body, which is a little bit more.
How long was the course? Oh, I see, it's a 35-hour.
It was about 35 hours.
You did it
It was
online?
great. It's an online course.
Your massage courses are online.
But also my aesthetics training was an advanced aesthetics training. Also, my previous jobs I had rigorous trainings. I traveled doing product training with employees. I participated in global trainings at the Institute, the Erna Laszlo Institute. So I really, I think I've had an advanced education in aesthetics, and I still study on my own, and with having taken postgraduate classes. So I kind of started in the industry in a sort of a higher footing, if that makes a difference.
The only component she's missing is the correct work experience.
Hours, I think.
I don't have the
Hours.
500 hours.
It would be 150 hours
Yeah.
she's missing.
I was hoping with everything that I've done and all the hard work I put in would kind of preclude the.
She's had both exams.
I've taken the practical and the.
Right, New York, just their hours is the issue. And again, with all the additional hours she's done, I'm not sure what the school would teach her in the 150
Right.
she'd be missing,
She probably knows more than what she would learn there.
based on what I'm reading.
Mhm.
Mona might have another opinion, but
I'd second that.
A motion and a second that we grant reciprocity. All in favor?
Aye.
Aye.
Motion carries.
Well, thank you so much.
Good luck
Good
to you.
luck.
Good luck.
Thank you.
congratulations.
And next, we have an application for reciprocity for cosmetology license from Florida for Rebecca Spinato. Certification shows initial licensure in April 1997 with 1,200 hours and no practical examination. Ms. Spinato provided sufficient documents regarding her work experience, but she's missing the practical exam. She emailed a letter, pardon me, okay, requesting the board consider her 20 years' experience and waive the practical. My recommendation is that we do that and honor her reciprocity application.
Make a motion for reciprocity upon Roxana's recommendation.
Second.
Motion and a second that we grant reciprocity. All in favor?
Aye.
Motion carries.
Next, we have an application for a cosmetology license from Maryland for Brian Tren. Certification shows initial licensure in February 2016 with 1,500 hours through reciprocity, and they do require both examinations. The reciprocity is from North Carolina. You can see this on page 93 on the certification. Upon further questioning and asking for the certification from North Carolina, one could not be obtained. I was able to speak to the Maryland State Board and question some of this. They will be opening a complaint and possible revocation against Mr. Twen, because North Carolina certification is actually false. The information means that therefore Maryland certification is not accurate and does not qualify him to meet the minimum requirements. Mr. Twain currently does have a manicurist license. Regarding his current request for cosmetology, my recommendation is that we deny it.
Motion to deny.
Second.
Where is his manicurist license from?
So his manicurist license is reciprocity, and it's not from North Carolina. I meant to be honest with you, there were so many on this meeting that I didn't get as far as I would have liked to. I know it's reciprocity, but I don't have the state, but he's been licensed with us since 1996 for his manicurist license. So there's no doubt that it probably is a legitimate license.
On the cosmetology?
It's manicures. Now he's wanting cosmetology, whether it's to do additional aesthetics kind of things or the full, I don't know. When I spoke to him directly, I said, you know, we're looking for this North Carolina information. And he kept saying, no, I have nothing from North Carolina. He was forgetting that, of course, the Maryland certificate would point to it and we'd be in a circle. So it is the board's decision if we want to open a complaint against his manicurist license. I'm not pursuing this at this time, but obviously the fraudulent information from North Carolina is something he'll have to deal with from Maryland. We're denying it. He's been licensed in the state since '96 with no complaints on his manicurist license.
We have a motion and a second to deny his
Correct.
request for this cosmetology license, and all in favor? Aye. Motion carries.
Next, we have an application for reciprocity of master barber license from Kentucky for Kimberly Vanover. Certification shows an initial licensure in June 2016 by examination with 1,529 hours. Kentucky has a probationary period where an individual must complete 6 months of working under this probationary license, and therefore, for our minimum requirements, we need an active license, which is the reason this is before the board. I recommend that we approve reciprocity.
Fairly familiar with the way the Kentucky system is, and the Kentucky system is pretty tough. Programs, then you do apprenticeship, then you come back and take your tests. And I'd move that we approve reciprocity.
Second.
Motion and a second that we grant reciprocity. All in favor?
Aye.
Motion carries.
To look at the scores, I'm sorry, because as soon as you said and then take exams, but they actually, for the probationary license, test them, so that was the reason for I doubt it myself. All right, next we have an application for reciprocity with education obtained in Mexico in cosmetology for Patricia Vargas. Various documents were provided to the board office, including certificates and diplomas. The translated educational form shows she completed 1,170 hours in 2008 through 2009. Ms. Vargas completed an additional 520 hours at Sheer Perfection Academy to give her the necessary hours as well as to prepare for the examination. My recommendation is that she take the Tennessee exams.
Make a motion for take the exams.
Second.
Motion and a second that you take both Tennessee exams. All in favor?
Aye.
Motion carries.
Thank you. Thank you for letting me rush through these. I apologize. It gives us about 5 minutes. If the board has any questions, we can go over them. Otherwise, we'll conclude. Betty, I'll let you turn it off. Thank you
Good.
very much. We're done with reciprocity.
Thanks.
Thank you.
So, my friends, how have y'all been?
Hey, she's been real good. Ask her what's new in her life.
This meeting of the Tennessee Cosmetology and Barber Board of Examiners is called to order. Ms. Roxana, I think we'll start off with a roll call.
Thank you and good morning. Today is Monday, August the 8th. We are starting our full meeting at 10:25 in the morning. Thank you for being here. I will start with Ms. Kelly Barger,
Here.
Anita Charlton, Ms. Nina Coppinger,
Present?
Mr. Bobby Finger,
Here.
Ron Gillahan,
Here.
Ms. Brenda Graham,
Here.
Ms. Wyvette Granger,
Present.
Ms. Judy McAllister, Ms. Patricia Richmond,
Here.
Ms. Mona Sappenfield,
Here.
Ms. Amy Tansley.
Here.
Thank you. We've got 9 board members here. Thank you, Mr. Chair.
As we get started, we always like to take a moment to welcome our guests. So thank you all for turning out. We got quite a nice crowd today. We didn't have a meeting last month, so it's good to see everybody again. Do we have any schools that are represented here today? Any students? Okay. Could one of you from each of your schools stand up and tell us which school you're from? Thank you. Nice to have you. Great to see you folks. Anybody else? Okay. Oh, thank you, ma'am. Welcome. Thank you for being here. We would need to have a motion for the approval of the June 6th meeting minutes.
I move that we approve.
A second.
We have a motion and a second to approve the June 6 minutes. All in favor, say aye.
Aye.
Opposed, say no. Motion carries. Ms. Roxana?
Thank you. We will start with our, on your iPads, our first school presentations on page 3. This is Sheer Perfection Academy of Cosmetology, their new Nashville campus. And we have before you the co-owners, Mr. Elvin Mejia and Ms. Ellen Tahari. If you'll come up. The red light is on.
Sure.
Welcome. Thank you for coming.
You have their application for both a cosmetology and a barber school license in front of you. This is the school's second campus. They have the floor plan provided, student agreement, curriculum, applications, and fees have all been received in the board office. The school is ready for inspection, so we can discuss that at the ending of everything you review. The barber school, per the new rules, do require 15 tentative contracts. It's a very new item, and so with the board's approval of everything else meets and all your questions are answered when we set the inspection, I will make sure that the office receives the 15 contracts beforehand. At this point, we don't have those, and it's just hard to get them. And again, it's such a new rule that some of the schools applying for barbering haven't noticed that that's pending. So I will turn it over to the board for any questions you have.
Going to take just a minute to review your application.
Are you offering the apprenticeship program through your school?
Yes.
My recommendation would be for you to add that on your contract and mark it. Just that way you'll know for your own tracking.
It has to be designated. what
Yes,
they're-
and it has to be yes or no when they start.
Also, I see under your apprenticeship program, you're going to allow the student to complete 800 clock hours in the school and 750 clock hours in the salon. The school has to be 50/50, or the apprenticeship has to be 50/50.
That is not optional. The law is 50%.
Yeah. Have a plan for the salons that are going to take on your apprenticeship? Have you got a little form for them fixed up?
Yes, we do.
Okay.
We've been talking to a school, a salon's owner as well around the area.
I noted on page 2, there is a check and signature for acceptance.
I can't hear you, Ms. Moon, if you'll make sure.
Noted on page 2 of, I guess this is the enrollment agreement, there is, if you are interested in apprenticeship program, you need to let the school official know upon enrollment. And then there's a initial there, and it is bold and underlined, so
Right.
it's there.
Right.
Roxana, the first floor plan we're looking at here, I think it's on page 10. Is that for the cosmetology part, or is this the entire school?
Our school. And I'll let you also ask some of those questions. I did not see a full square footage of the space that you have. Alvin, how much is it?
And it's 3,800.
Okay. We discussed it, and it was plenty big, I just didn't see it.
Do you have a teach-out program? In case you were to close, do you have a teach-out program with another school?
Excuse me, I didn't hear you right.
Do you have a teach-out program in place in case you close?
A teacher?
Teach out.
You have an agreement with another school in case you were to close?
Yes, yes,
How you
we
would handle your students?
Yes, it will be White House, Tennessee.
It'll be their second campus, so they've got the other one.
Yeah, okay.
How were the students made aware that if you have an issue, that they would be able to do that?
Yes, I have informed them.
How do you inform them?
The student,
Yes. How do you inform the student what their options are in case the school were to close for some reason?
okay, we normally communicate with them. Mostly myself, because I'm the director, I let them know in case we close down, they have the option to go to White House, Tennessee.
Are they informed of that before they enroll?
Yes.
Okay.
Anything else over there, Ron, that catches your eye?
I'm still looking at the floor plan here. May be missing something here in this first floor plan. I don't see a layout of where the differences are for the cosmetology chairs will be for their
On the
stations.
floor?
Mhm.
Yeah, it's right in the front when you come in. So in the middle.
Not for the classroom, I mean for the actual practical area. Are you planning on having the barbers and the cosmetology share a practical area?
Yes, we do, but it's other way in the back. We have a different room.
Okay, so the cosmetologist who's working on the floor in a chair, working on a customer or mannequin, are they going to be sharing the same station as the barber?
It will be in the separate side. Okay.
I don't see the other room you're talking about.
It's in this side, the barber will be in this side.
The bottom chairs where it says floor plan are the ones that are barber?
Yes.
Okay.
See manicures.
So the 5 chairs, what Mr. Smith has pointed out is right above the words floor plan, you've got 5 chairs. Those would be the barbering, and on the opposite side is where they're listing the cosmetology. And there's 1, 2, 3, 4, 5, 6, 8 on the other side.
I can see some of this copy's a little bit fuzzy here. 1, 2, 3, 4, 5, 6.
Each area have to be marked barber or cosmetology.
The board has done in the past with the duly licensed schools is as long as there's clear layout for the public as to where they're going. We've had some schools do signs, others have used division of,
Curtains and stuff like that. I think.
I think there was a supply room in one of the cases that divided them. So it's not that we've stuck to them having to be completely separated, but there has to be some, yes, so that the public knows what service they're going to. Several of the schools have also done it closest to the classroom that the students are coming from, so we've been flexible definitely in looking at that.
Do you intend, I see just the 5 manicure stations, I think. Do you intend for the barbers to share those same stations as well?
Yes, sir.
How are they going to do that at the same time?
Oh, the barbering, they normally have one section already, the barbering, which is in the back. The cosmetology is there on the front. That's what makes them divide, where barbering is going to be in one section and cosmetology would be in another section, which we already have over 22 stations.
Are all your students full-time?
Yes.
I'm sorry, I don't mean to just keep coming back to this, but it's just, something's not clicking in my mind, I guess. You just said you have 22 stations,
Yes, we do.
okay? Barbers will need 15, and the cosmetology will need 20. So that would be 35. Not the way we've been doing that. I may be a little fuzzy on that. Roxanne.
Checking with Laura, the cosmetology change that no longer requires 20 applicants would mean possibly that, I mean, you still have to open, I think, with a minimum of the 5 stations, no matter what. But it isn't written anywhere that they'd have to have 20 full and separated. So that's a good question.
That's something that just went over my head. I'm sorry. I'll move on.
On the enrollment contract page, there's a place to check for full-time or part-time. Did you say that they're all full-time?
There are full-time and part-time as well.
Okay. And then on the enrollment contract where it says education, high school, or GED, are they supposed to put yes or no, or where they?
Yes, they're supposed to put diploma, high school, GED, whatever they have complete in their education.
File 9, they have to have a copy of that contract.
Do they have a copy of the transcript or the diploma, or this GED score page?
And it could be the GED,
Yeah.
high school diploma as well.
Well, and then there's the HiSET, which is also up-and-coming test that's going to probably replace the GED or something. I don't know, but you might want to clean up the typo under education where it says HAT. This agreement is entered into between Sheer Perfection Academy of Cosmetology and applicant. That HAT for, I mean, you might want to fix that.
Is this the same contract that you use at your other school?
Yes.
Okay.
Yes.
Do you have a catalog?
Yes, we do.
Okay. Part of the submission package, Roxana?
I don't have a current catalog, no.
Okay.
Okay.
I have one more question. Are you planning on changing really anything in how you do business with your new location as opposed to your old?
At this point, no, we got to keep it the same, so
Yeah.
students will have the option whether they feel comfortable to go to White House or stay in Nashville.
Right. So this looks good to me.
How many instructors do you have?
Right now, I have about 3.
3 for each program?
Yes.
Okay. Good.
Also looking to hire some more, so.
Questions?
I'm good. Are you good with the chairs and the stations and stuff? Are you still confused?
And I think I see what he's going for here. Okay. Okay. Do we have a motion?
I have a motion to approve.
Do I have a second?
Second?
We have a motion and a second to approve. All in favor, say aye.
Aye.
Opposed, say no. Motion carries. Good luck. Congratulations.
I want to say something real quick. I've been in this business for more than 15 years. I've been living in Nashville, and I've seen the changes and the growth as you guys have been doing. And I just want to say, as a director and a school owner, that you guys doing a fantastic job, especially Ms. Roxanne as well, helping my Spanish community that they come all confusing with so many different situations. And she's been helping me a lot as well, you know, helping those students. And that's what we're here to do, to help students to get a better education and to help, you know, them from anywhere, any country they come in. But you guys are doing a fantastic job, and I want to thank you guys for that.
Thank you.
Appreciate that. Students, good luck.
If we can clarify for that application, before we issue the barber license, we'll make sure to have the 15 contracts. You are ready to be inspected, am I correct?
Yes.
Okay.
Friday, would that be good?
We'll need a board member and field inspector. The field inspector is not a problem. They are here in the middle Tennessee area. I can check with both Ms. Tanksley and Ms. Allen to see what dates will work out, if that's okay.
Happy to do it. I can't do it this Friday, but I would love to come.
Okay. We'll look at the possibilities.
Also an updated catalog.
Pardon me?
Also an updated catalog.
Oh, yes, catalog. Thank you. Okay.
Roxanne, just email me and we'll
I
figure it out.
will. Look at a date. Thank you very much.
No problem.
Next on your iPads is an application also for a new school. This is Crown School of Trades and Technology. Mr. Michael Nabe is appearing before the board. Mr. Nabe?
Thank you for coming. Welcome.
Okay, you have on your iPads, this is an application for a new school. The location is in Powell. Section of this school is going to be used, the section that will be used, because they have various programs, is the 3,000 square feet. The floor plan, student agreement, curriculum, application and fees have all been received. This school as well is ready for inspection. This is a very different, unique thing coming into Tennessee. I'm going to give the board plenty of time to look at it. I've had the pleasure of speaking with Mr. Mabe and know that they're looking at doing an interesting new concept there. To review and ask any questions.
Is this at Crown College location?
We're connected to Ground College, yes,
Okay,
we are.
that's my neighborhood. So I was trying to figure out where it was on Beaver Creek. Okay.
So it's like a boarding school?
We lease part of the property from Crown College. It's a huge campus, and we have several hundred square feet of the trade school in part of their building. And there is dormitory available for any students that come in through Crown College. But it's not a boarding, like a normal college. Students coming from out of town, they could stay in the dorms there. And we have a few students in the cosmetology program coming from out of town And then if that's the case, then, you know, we have an agreement with Crown College that they could stay in Crown's dorms. You know, it's part of our lease agreement with them, that the student then could contract with Crown College to stay in their dorms at an additional charge, of course, through Crown.
How is it listed as a nonprofit?
Well, it's a private school through the Crown College is originally, well, still is, it's a Bible college. And it got its own board of directors. Crown School of Cosmetology has its own board members, president, and it's a nonprofit. We're just, much of the operation expense and tuition is through contributions from individuals.
But you're still charging tuition for the
We are.
school.
We are, but it's a small portion to what it's actually costing, yeah.
Like your layout. Again, I'll have to ask you, do you have sufficient staff of instructors for the program?
Yes, sir, we do.
More than one, right? Okay.
So will you be offering the specialty licenses also, the esthetician, manicuring, and
Full cosmetology diploma, where they would be the hairstyling, manicure, pedicure, facials. Yes, ma'am.
I think to Ms. Mona's question was, will you also just offer the smaller licenses, the manicuring or the aesthetics, as opposed to just the full cosmetology? If a student came to you and wanted to do aesthetics, would you offer it?
No, we're not at this time.
Do you have a teach-out program
In case of,
in case of a closure or?
yes, we do. We're actually in communication right now with some local, some other local schools. We don't have that totally nailed down yet, but they seem to be very interested in. In fact, a couple very eager, if that were to happen, to take our students.
Plenty of options, probably, in the
Yes.
area.
sure.
I didn't see a catalog here for you either. Has he submitted his catalog?
No, and in the past, we haven't always gotten them, actually. I think it's a great idea. I don't know that every school does that type of marketing expense, but I think when I get it, we scan it so that the board can see it. But I think it's a great thing. We want to start asking for it at the time of inspection to make sure that the board member can review it.
Whenever they, when we talked about best practices a while
Yeah.
back, we had discussed
Absolutely.
some of those things.
Y'all be doing the apprenticeship program also? Okay.
We have the 20 contracts, or the requirements on that.
Don't need 20 anymore
Oh,
for
anymore.
cosmetology. All they need to now provide is one blank
Oh,
full.
I see. Okay.
Will you be offering scholarships to some of the students?
We do offer scholarships to some of the students through some foundations that have been set up through certain individuals, and yes, we do. Students apply for those scholarships and, you know, meet certain criteria clearly stated for.
In your refund policy, I see you've got a refund policy here. It does say how you'll process those things, but it didn't say if there's a time frame in there, 30 days, 45 days. If you have a time frame on when you'll be doing that.
Usually, if within the first 30 days, it's a full refund, but then sort of prorated after that, certain percentage is refunded.
You might want to add something like that in your
Verify that.
contract, so a student would know
Yes, sir.
what their rights are.
I was looking in this curriculum, and it may be in a capsule of career development principles, but there's not a component that I can see clearly that is the business and the cosmetology law for the students, which is part of the curriculum generally.
Yeah, it's partly in that one, and then also, if you look a little bit further down, there's a salon management class. Part of it's in that. Yes,
That's not on my page, but
I don't think we've got anything but the freshman, spring, and fall semester. Oh, that's okay.
we do cover that, yes, ma'am.
if someone was in a capsule trying to get reciprocity and they needed that component, as we've seen many times on the board, would you be doing increments of that, the components in the semester, or are you just taking full-time, beginning to end students?
Well, we've thought about that. Right at this point, they have to complete the full program to get, not a portion.
Just a question.
Yeah, they have to complete it all.
What textbooks are you using? The lady, okay.
Do you have anything in your program that deals with employment after the student finishes your courses?
Yes, sir, we do. We have, we're really seriously, taking that very seriously about helping them find employment. And we have other trade programs in the trade school already, and we've been very successful in finding employment for every graduate. And we will be very involved in their job placement, not only while they're maybe they're in the area or wherever they might go. We'll do our best to get them placed. We spell that out in our catalog, but I need to get you a copy of that.
In your curriculum here, under the freshman year, fall semester, of course, I see your weeks and everything. Do we have a breakdown on how that's going to correlate to the hours as far as the program is completed, Roxana?
I don't think so. I think the programs are by a number of weeks instead of hours. Am I correct?
Yes, but in our own, with our teacher and staff, we have broken that down to where we are giving, ample time to every aspect of the training, and we do include hours. Where you have the weeks there, it's sort of a total of the amount of time it takes to cover that particular, and there's some sub headings underneath that, and each one of them takes so many hours and covers them that amount of weeks. In our catalog, we do spell that out in a little more detail too, so maybe.
Have any other questions? Do you have a motion?
Make a motion to approve.
Second?
We have a motion and a second to approve. All in favor, say aye.
Aye.
Motion carries. Congratulations. Good luck.
Thank you very much.
Barger, I'll get with you so we can coordinate the inspection, and I'll let them know. Thank you. Okay, next we have a change of location. This is Belladonna's Academy of Cosmetology, and Ms. Donna Byton is up here before the board.
Hello. Thank you for coming.
Hi there.
This is a change of location for a school located in Kingsport, You've got the floor plan for your review. The application fees have been received. The school is also ready for inspection. They were actually ready last month, but given that we didn't have a board meeting, I know she's pressed for trying to get her school and her students moved over and get the timing of this. I'll let you ask her any questions that you've got. And in this particular case, with a change in location, it's really the floor plan that's at stake. What is the total square footage?
2,400.
Thank you.
Really small classroom there.
It's a 20 by 16, I believe.
Oh, I'm sorry, I was looking at the one in the right by the front, or by the wax. Okay. Moving to a new town, or is it just across town, or?
Across town, right down in the downtown part of it. It's a
Oh.
freestanding building. It's got its parking of its own. That's the main purpose of moving.
How long have you been operating your school?
A year and a half,
The original location?
the original
Okay.
location. Yeah, I just purchased it last year.
That's right,
From
okay.
Carter's, yeah.
Don't anticipate any kind of difficulty for your students traveling that far to
Oh,
change? Okay.
No, not a bit. Actually, a lot of them say it's better for them, the new location is.
Since you don't have all of your chairs located here or drawn out anything, is your intention to put them in the center of this clinic floor? Can you tell me about
Yes.
that a little bit?
Yes,
5 squares I'm looking at, is that your
shampoo bowls.
shampoo bowls? Okay.
Everything that I see that she needs. So I'll make a motion to approve.
Is there a restroom?
Yes, there's 2.
Oh, I see.
Second?
We have a motion and a second to approve this change of location. All in favor say aye.
Aye.
Motion carries. Good luck.
We will coordinate to do this field inspection as quickly as possible. I'm not sure off the top of my head who would be inspecting Kingsport, so I think Ms. Allen might be able to. And next on your iPads, we have also a new school application. This is a cosmetology and barber school, Pyramid Beauty School, out of the Memphis area. Mr. Cleophas Bryant is appearing before the board. Hi. Okay, I met you in February. Nice to meet you. If you've got anything to report us, give it to me.
Hello, Mr. Bryant. Thank you for coming in. Appreciate it.
You have on your iPads an application for a cosmetology school, a barber school. You have a second set of the same documents. They were submitted to the board office twice. You also have before you floor plans, student agreement, the curriculum. Applications and fees have been received by the board office. I will let the board review all of the documents. I'm going to turn it over to Attorney Anthony Glandorf. He'll be happy to answer some questions and fill you in as well. And I think you've got everything on your iPads that the board received.
Hello. Thank you for coming in, Tony.
My name is Tony Glandorf. I'm the Chief Counsel for the Regulatory Boards Division here at the Commerce and Insurance. And I'm here before you today to discuss the application for Pyramid Beauty Schools 2 and to give you some history on this this school and this application and give you my thoughts on this application. In short, as your Chief Counsel, I'm going to recommend a denial of this application based on the idea and my belief that this application, that Mr. Cleophas Bryant Jr., the son of Miss Lois Bryant, is the listed owner of this school, but I believe that he is a straw man and that this is an attempt of Miss Lois Bryant to regain control of a school that's previously been revoked, just recently been revoked, and whose revocation of its license was actually upheld Chancery Court in Davidson County. I do not say this lightly. I do not come to you all before you lightly and make these allegations, but it is my sincere belief that going forward and approving this school will cause potential harm to the public. I'll have some documents to pass out to you, and I'll give some to Mr. Bryant also, but to recap, I have to bring you back into some history of the previous school and how we've gotten to where we are today, because there is some information to be had. Back in 2015, there were complaints against the previous Pyramid Beauty School, which was a cosmetology and barber school. The allegations of some of these complaints came from former students. Some of those complaints were regarding the inappropriate administration of VA benefits and encouraging students to obtain VA benefits when it wasn't necessary for them to do so. There was also, from our own inspection, there was incorrect instructors, essentially barber instructors, that were being reported for a cosmetology school. And a third, and the one that was one of the most disturbing allegations, was that there was a gun being brandished within the shop by somebody there, and that the management of the school told the students not to make any statements about a gun being brandished in the shop. Due to these things, we brought this to the board about these allegations. We had probable cause that the allegations were true. We recommended revocation of both schools' licenses, which you all gave us authority to settle this matter. We generally make those settlements through consent orders, where we send and mail a consent order with our allegations of fact to the respondent. We received that order back from Pyramid. It was signed by Ms. Lois Bryant. It was signed in approximately September 2015, which essentially would revoke both the school licenses. Sometime after that, there was a litigation that ensued in Chancery Court, where Pyramid Beauty School sued this board, claiming that her revocation of the license was not a true revocation. It was a mistake that was done. The department took that stance very serious regarding the allegations and the facts involved. And so we defended, the Attorney General's office defended that suit, which I was involved in assisting going forward with that suit, along with Laura Martin, your board attorney. During the pendency of that litigation, Pyramid Beauty School was represented by an attorney named Kyle's Motherhead, and we communicated with him in approximately January 2016, because this board received another application for a location at Pyramid Beauty School named Pyramid Beauty School 2. The new owner would have been Cleophas Bryant Jr. on that application. Because this was the pendency of a lawsuit, our office had to respect the application of going forward as an application, but at the same time recognize that we were defending a lawsuit where the current supposed owner, the Pyramid Beauty School, was alleging that they still had a good school license, but at the same time we had an applicant for the same location saying that they had the same equipment. So we were about to potentially license have two licenses at one location. Because of that, we indicated that we wouldn't process the application for the new school until we had issues resolved with the current litigation in Chancery Court. That only being the reasonable answer we could come up with, because worst case scenario, if the board lost in Chancery Court, we would have two licensed entities at one location, which cannot be. During the pendency of this litigation, as I indicated to you, we received a new application, and I'll get to some of the facts as to why I think that Ms. Lois Bryant is a part of this applicant, is because the original application that we had. Well, let me talk to you about the application that we received in January 2014. Had an email address on there that indicated Lois, Lois owner 99@gmail.com. Prior to this, in 2015, Ms. Gamusio's staff has been communicating with Ms. Lois Bryant, one of the owners of Pyramid Beauty School, during a normal course of business through the email address loisowner4261@aol.com. Now, when we receive both emails, they both indicate from the email itself that the owner of the email address is Lois Bryant. That raised some concern with us. It wasn't a concern so far as to say that we're not going to do anything with this application or deny it right then, because it needs to come to the board for that determination. And so we progressed forward. However, in January 14th, in January, and I'll pass out these emails to you all. January 2014, while we were in dependency of the lawsuit in Chancery Court, we notified our attorney, Brad Buchanan, at the Attorney General's office that we received this application, so that he knew that. He reached out to Ms. Pyramid's Beauty School's attorney, Kyle's Motherhead, and indicated that they had received an application with Ms. Lois Bryant's son as the applicant. And so the board, and so the question was asked, and if you turn to, you'll see some of that information. On the top of page 2, you will see the attorney for Pyramid Beauty School asking our attorney, and Pyramid Beauty School is completely separate from supposed to be completely separate from the applicant today. So my client is asking, and I'll read it as quote, so my client is asking whether her son's application could proceed in parallel if he had his own location and equipment. I'm assuming that it could. Do you see any reason that it wouldn't be treated just as a separate application at that point? And then the next line is, she's also asking if your client is willing to consider any kind of settlement on her license. I told her I would ask. And so that is the original communication that we had with their attorney regarding that. So going forward with the settlement offers, there was no settlement offers that were taken regarding the keeping of the license or revoking of a license or surrendering of a license with a new application. The department was not willing to entertain that question, since we'd already been in the midst of the lawsuit for that. Now, I indicated earlier that the previous communications that we had in 2015 were all with the email address loisowner4261@aol.com. I believe we saw earlier that the previous application came with a email address loisowner99@gmail.com that I believe you all have in front of you. This to me shows that there's a strikingly similarity in the email addresses, and it gives me pause and concern as to why somebody would have an email address with their mother's name on it saying owner. Now, this is not, I understand this is just circumstantial evidence that we're looking at, but at the time it provides pause to us. That's why we did that. So if we fast forward during the pendency of the litigation, in May 31st, the board received an email through our automated computer system called Zandesk from the original email address that was used by Ms. Lois Bryant. It is loisowner4261@aol.com. And it has a change of ownership application indicating that the owner is Cleophas Bryant Jr. So this is where we start to have some more serious confusion as to who the board is actually speaking with when they talk about this application process, because we were under the impression that we were communicating with Cleophas Bryant Jr. previously based on his application, though he had an email address similar to the one previously used. Now we have in what our documents say is the email address of Ms. Lois Bryant talking and communicating with the board regarding this same matter, providing a new application form. And I'll give you a copy of these email addresses of these emails. That we have, where it shows this information. If you look specifically on the bottom of page 1, this is an email copied from Ms. Roxana Gamusio to ownerlois4261@aol.com, and I have to explain to you the way that this email address got to, so that Roxana typed it in, is that this is the email that came through our automated system Zendesk. And you can see the confusion because she emails to Mr. Cleophas Bryant Jr. But we know that this was the email previously used from Ms. Lois Bryant. However, the information that came in was for an application for Mr. Cleophas Bryant Jr. So you'll see that. You'll also see on the bottom of page 3, there is a box that says Ms. Bryant, and it has attachment scan 0006.pdf, and underneath there, automated from Zendesk, is the requester being Ms. Bryant, and you will see on what would have been page 4 and 5, you can see a new school application regarding owner Lois4261@aol.com, that being the alleged email address of the owner, Cleophas Bryant Jr., signed there by Mr. Bryant. So it was at this point in time when the application moved forward. If we fast forward a month or so, the litigation going on in Chancery Court was actually made. There was a determination that was made, and there was an order that we received regarding that. And the chancellor in that case, Chancellor Bonnyman, wrote an order, drafted an order, where there was, after a full hearing regarding the merits of the case, regarding all the allegations regarding that the consent order previously signed by Ms. Bryant was a mistake. The order came from the chancellor finding in favor of the board and of the department, stating that the mistake of signing the consent order was a unilateral mistake, and as such, the consent order in itself stands as it is, which is a revocation of both schools. So currently at this time, Pyramid Beauty Schools, the Cosmetology and Barber School are both have a revoked license. Copies of the consent order were a part of our closing documents, and within the final order, I would like to point out that these were some of the issues regarding the allegations that were stated, which was during the consent order we made allegations that there was a weapon branded within the school, and the student made such. During the pendency of this lawsuit, there was a response made, and prior to the lawsuit, Ms. Lois Bryant made a response, and she says this in her complaint, in her response to the complaint, and I quote, and the court noted this in its order. This is Mrs. Bryant's statement. Last but not least, the weapon complaint is not true. I always have my weapon with me at all times because I'm a businesswoman. I have to be protected at all times, even my own business. I have the right to carry a weapon because I hold a weapon permit, and I would not do anything to put myself, business, or students in danger. I also know that even in the most comfortable places, anything could happen, but I never have my weapon out in the open. I always have it concealed. Prior to this statement, we did not know exactly who had the weapon, but this statement from Ms. Bryant indicates that at least she had a weapon. So these are the issues that I wanted to point out to the board as to why I believe that there's a potential danger to the health, safety, welfare if this school applicant is going forward. However, I'm still not finished to provide you with more information as to the connection of these email addresses and why we believe that Ms. Bryant is actually part of the applicant process here, not just her son, Mr. Cleophas Bryant. So the documents that we brought. So prior to this meeting, I had a conversation with Ms. Roxana as to the whether or not this application was ready for review is going to be brought to you all, and she said it was. And so I asked Ms. Gamusio, could you please contact Mr. Bryant and ask him why his email address appears to be his mother's email address, and we were thinking of the differences in email addresses we had back and forth. The response that we got is not the response that I thought that we would receive, which was not just a explanation so much, but it seemed to be very defensive in its nature and sheds light to some of the questions that we had. So if you look on page 3, if I could orient you to page 3, in the middle of the page, there is a email from Roxana. It's one line, so it's easily missed. It says, "I'm finalizing everything for the board meeting. I've meant to ask you why use your mother's email address? Thank you for your response." And Mr. Cleophas Bryant's email response from owner Lois99@gmail indicates at the top of page 3, actually, this is my email that I've had for years. It just has my mother's name attached to it. She doesn't have access to this email. Everything comes to me. If there's a problem, I'll create another one specifically, but I've had this email for almost 7 years. So Lois Owners 99@gmail has been an email address that he's had for 7 years, is what that indicates. So if you look on the top of page 1, sorry, at the middle of page 1, this is Mr. Bryant's response back, because Ms. Gramusio replied back saying that they believed that they had been communicating with Ms. Bryant before, and were worried about not knowing who the person was using the email that was corresponding with it. And Mr. Bryant replies back on middle of page 1, says this email associated with Pyramid Beauty School was owner Lois4261@AOL.com, which we just saw earlier that in May 31st, that was the email address that sent us new applications. So this is, in fact, the old Pyramid Beauty School email address. My email is owner Lois99@gmail.com. If it's mistaken as an email for personal purposes, this is my personal email. Could you explain to me what your concern is? If it is a problem, I'll be happy to get my lawyer involved so we can communicate through him, since communicating with me directly is causing problems. I would rather get everything done by communicating amongst us. If anything, when we first started this process, both of the emails were given so that I could get the information as well as my mom. Once again, she has no affiliation with owner Lois99@gmail.com. And owner Lois99@gmail.com has never been affiliated with anything dealing with the school until now in 2016, which that is my understanding correct. It's not. However, it appears that we've had 2 email addresses, owner Lois4261@AOL.com. So this is Mr. Bryant saying that his mother has been part of this process. Now, I understand that's probably absolutely true, which is that during the pendency of the litigation, there was an attempt to create a new school under a new owner. In order to move the school to go forward. Now, under Tennessee jurisprudence, there is reported cases, there are unreported cases from the Eastern District of Tennessee that stands for this, which is the board does not have to approve a license where they believe that there is a straw man, where they believe that somebody is reported as the owner applicant who is not going to be the true owner applicant, even though they may have all of the legal documentations and papers and all of that correctly. If everything points to the fact that this is not true, then the board can deny the license. In the Tennessee Court of Appeals in the Eastern District of Tennessee stated that back in 1992 under a case which was Tana Lee Ammons versus J.C. Wallen, which was before the ABC board. In that case, there was a previous owner who was a husband whose license was denied, and the wife applied under her name using the exact same material documentation that was under the husband, and the court said that they could deny that license. If I could turn you to the application that's before you today, I think there are other things that show that there has not been a complete separation between the applicant Pyramid Beauty 2 and Pyramid Beauty School previously. I believe as part of the applications you have some documentation which indicates that you have a license for Pyramid Beauty School 2. You do have that. You have a lease agreement, and I have to point out that the property, as my understanding, is owned by Ms. Lois Bryant and Mr. Cleophas Bryant Jr., which means that if you all approve a license to Mr. Cleophas Bryant Jr. today regarding beauty school, there's no way that this board could stop or enjoin Ms. Lois Bryant from not going into that school any given day that she would want to, other than through the lease agreement that she would have with her son. So for all intents and purposes, if it's not addressed in a lease agreement, she could be in that building all day long, and the board could not enjoin her from doing so because she is a property owner, or I would suggest the board should not attempt to do so because she is the property owner. If you will look, I believe that you have documentation here on the course outline brief guide, on the last page and the next to last page, which has a Pyramid Beauty School, the previous licensee, These are documents from the previous licensee under 1292 Madison Avenue, the same location as the school is going to now. Therefore, that part of this application appears to me to be the exact same documentation that was used at Pyramid Beauty School. We have the exact same location. My understanding is we have the very similar equipment that is going in the school. The location is the same. The only difference that we have here, essentially, the main difference is that we have basically a new person is changing as the owner, which is Cleophas Bryant Jr. I would like to point out that I have absolutely really no working knowledge as to Mr. Cleophas Jr. And the information I'm giving you is basically essentially indicating that I think that we have shown, the state has shown here, that there isn't a sufficient disconnect between what was previously Pyramid Beauty School, which is a revoked school, the owners of which you could deny being owners of schools in the future because they were previously owners of a revoked school. That there's not a sufficient separation, and all of the information, given that it has provided overlap from the previous school, provides information that the board could deny the license on. Specifically, you could deny based on 62-4-127B1 and 2 regarding fraud in the procurement of a license, and also in unprofessional immoral conduct of attempting to subvert the laws of the state of Tennessee by changing just the ownership name, keeping everything remaining the same, and indicating that the previous owners will not be involved. We know that the owners will be involved because they have a financial vested interest in the leasing of that building to their son and the viability of the school. I'm now open to entertain any questions that you may have from me regarding any of this.
I think you've answered them all.
Good presentation.
All right, what say you?
Yes, sir.
I'm Cleophas Bryant Sr.
I'm sorry, sir, I'd like to hear from the owner.
Okay, go ahead.
What was the question, sir?
You've heard what the state's attorney has had to say here. What do you have to say in regard to this situation? I'm sorry, we can't hear you. Come up to the microphone.
Yeah, basically, we opened up a new school. All those allegations, that's in the past. We're opening up a new school today, or next week. That was my mom, she had problems, so I'm trying to open it up, behind her, but she's leaving everything over to me, so all I have to say.
I think I've heard enough. I'd like to make a motion to deny.
I'll second.
We have a motion and a second to deny. Is there any other discussion? All in favor, say aye.
Aye.
Motion carries. I'm sorry, sir, your application has been denied.
Ask a question.
No, sir, not this time.
Did I say something?
No, sir, I don't think we'll have any more testimony today.
Can I say something?
Okay.
Maybe suggest something?
Yes.
With you wanting to open another, Mr. Cleophas Jr., with you wanting to open another school, maybe it being in a totally different building and just being completely different and separate from what's been going on would be your best thing to do right now, because it's not looking good for you to open it in that same location with the same documents and everything. So maybe you just need to start over from a clean slate.
Ms. Granger. Okay, we will proceed. Next on your iPads, we are on page 66. This is Career Beauty College out of Nashville campus. Mr. and Mrs. Steve McMasters are here. This is for a change in ownership. I have before you an application for a cosmetology school located in Lawrenceburg. They are maintaining the school name. You have the floor plan, student agreement, curriculum, bill of sale, and application fees have all been received. This school is also ready to be inspected. I will give the board some time to take a look at those documents and then ask any questions that you may have.
Thank you for coming. Appreciate you waiting this morning.
And I'll remind the board that with a change of ownership, when it's something like this in Smooth, they can operate with the previous school's license. The issue for the cosmetology schools are they're all up for renewal this month, so they really do only have until the end of the month. Otherwise, they would have had a longer time, but we have a little bit more to get to inspect.
So they're operating now at that same location?
Yes,
Okay.
they are.
Have you made any pertinent changes to your contracts, your enrollment agreements, and so forth?
The enrollment agreement, there's some THEC qualifications that we're going.
Absolutely.
Yeah, we've got to get on standard with them, so, but other than that, no, sir.
Fun.
Yeah. And Ms. Roxanne had informed me that I gave you a pretty basic floor plan, and if it pleases the board, I do have a little bit better copy if you'd like to see it, with some square footage and some measurements and things like that on it.
In the same location, aren't you? I've been there before, yeah, it's a nice plan.
There been any problems in the past with this?
No, not at all.
I will abstain from voting on this, okay?
Can we see the plans that you have for us?
Will you be teaching the 3 separate programs, wearing cosmetology and aesthetics, or is it just the one license as the full service cosmetology?
Just the one license of full service. We do offer nail tech, but at this time, I do not have no nail techs.
Are both of you instructors?
No.
Do you have sufficient instructing staff?
I do.
Not just one?
Just more than one.
Roxana, does this have to be inspected when you have a change of ownership?
It is up to the board. There's nothing in the statute now that says a board member has to inspect, so it would be up to you. Since nothing has changed in the floor plan, I believe what the board has done is with the new schools or an expansion, we have just to make sure that the plan itself meets the minimum requirements and it makes sense for the public. In this particular case, they're not changing anything other than it's sold, so it'd be at your discretion to not have to send a board member and just the field inspector, and they'd be able to go out this week.
Questions? Do we have a motion?
Make a motion to approve.
Second?
We have a motion and a second to approve. All in favor say aye.
Aye.
Motion carries. Thank you very much. Good luck.
And are we going without a board member inspection?
Good luck to you.
Thank you.
Board okay to proceed with our applicants, or would you like to take a break? Mr. Chairman.
Good.
We're good? Okay. All right, we are on to our applications for examination. On your iPads, you are on page 79. These are applications for examination with felony charges for Dana Campbell, Jason McLinn, Christine Weidler. All have felony applications within the last 3 years or are currently incarcerated. They are requesting permission to take the Tennessee examination. The requirement is for them to complete the consent agreed order for a probationary period. The board does those for 2 years unless specifically noted to make a change. Did you want to hear any BARBERs? Yeah, I think there's one.
Do any of the incarcerations exceed the 2 years of probation?
Probation.
Would they still be incarcerated after 2 years?
With Mr. Jason, he has, I believe, 14 years. So, yes. And we've approved those before when they've expired, because the agreed order is from the minute we approve the license for 2 years. So the answer, I think, is yes, it would. And I will let Laura explain a change in the rule that does affect the felony piece for barbers, and only barbers, not cosmetologists.
If you guys might remember when we were doing legislative updates, there was a bill passed, it was Public Chapter 719, and it affected multiple professions throughout the state, one of them being barbers. And if, I'm just gonna reread it to you, it's very simple, but 62.3.121 was amended, and it now reads, conviction of a felony for the commission of an offense that bears directly on the person's fitness to practice competently as determined by the board. So what that means is that going forward with the barbers, if we're going to, so basically, this law has always allowed you to deny someone, or the laws have always allowed you to deny someone a license based on a felony conviction. I know that this board doesn't do that. Instead, we put them on a probationary agreement. And the reason that the board had the discretion to do that is because you already have the discretion to completely deny them. So this doesn't totally take away that discretion, but what it does do is it limits the times when that's appropriate. So here, it's not enough to say we're going to put him on a probationary licensure term because he was convicted of a felony. The board has to make a finding that the specific felony he's convicted of bears directly on his ability to practice competently. So it's a change in format. It means you need to look at the specific felony and then vote that yes, we think this specific felony will bear on his ability to practice. So going forward, when we're talking about felony applicants for barbers, we're going to have to treat them slightly differently. Are there any questions? Okay.
So, they're all requesting to take the exam, and then they'll be licensed, and I'm not familiar, but he will be able to practice in prison
Yes.
with his license?
Many of our, in the facilities, yes, they've got barbers that do not only the inmates, but possibly people that work there.
Yeah, well, I can't imagine any kind of felony preventing them to be able to do that. I know what you're saying, that we can look at them, but
I'm just saying going forward with all barbers, if you don't want to put them on probationary period because incarcerated and you think that it's just up to your discretion. We still, the board still puts almost everybody convicted of a felony on a probationary term.
Right.
But for barbers, if you want to do that, now you have to look at the felony and decide if you think it directly affects how they practice.
before we can put them on probationary period? Oh, just to deny it?
Yeah, but the reason, yes, but to put them on a probationary term, that comes from the board's, normally if somebody applies and they don't have a felony conviction, as long as they meet the requirements, and there's no statutory provision that would allow us to deny them, the board wouldn't deny them because legally it wouldn't be defensible. It would be seen as arbitrary. When somebody has been convicted of a felony, the statute for both cosmetologists and barbers allowed you to deny them completely from being licensed. This board has never really done that. Instead, what they chose to do was put them on a probationary term. But the ability to put them on a probationary term came from the discretion to deny them a license in the first place. So, if there's a barber who's been convicted of a felony and we want to put them on a probationary licensure term, before you can do that, the board just has to make a finding that the felony they've been convicted of directly bears on their fitness and competency of being a barber.
Okay, it gives us that option to deny it.
Yeah, you
because of
still
that.
have that option. It's just, it's no longer I know a lot of times you'll look through them all, you'll ask questions, and then you'll just vote at the end. Here, because he has to be treated differently than the rest of the cosmetologists, if you want to put him on a probationary period, you have to look at his specific conviction. I think he, is that it?
87.
Yeah, so he had a firearm, dangerous felony, and a second-degree conviction of murder. So you have to say, as a board, vote that being convicted of murder affects his fitness and competency to be a barber.
We would, if we wanted to put him on probation, that's what we have to do.
Yes.
Because of that.
It's just another step you have
Another
to take in the
step,
board
okay.
meeting. You still have the discretion, but now you have to make the finding. So if somebody was, I mean, I don't want to direct you, but a good example is maybe if somebody had been convicted of theft, and it wasn't, you know, credit card theft or the kind of theft that involves stealing identities, you as a board might think, well, this doesn't really have anything to do with them being a barber, so we're not going to make that finding. But say that they had assaulted someone with a dangerous weapon, and you thought, you know, we're licensing someone, and we think that the tools that they have could be used as dangerous weapons. We want to put them on a probationary term. The board has to make the finding that that conviction of assault with a dangerous weapon does bear directly on his fitness to practice.
Before we can deny it.
But before you can deny it, or, yes, before you can deny it. But since this board never denies and they put people on probation, you would have to, and I don't want to say never, you could. I'm saying in practice, generally, we haven't. You would have to make that finding before putting them on probation.
My thought is, I don't know, though. Was he incarcerated and then he went through the the barber program while he was there?
It appears to be. I don't have all of that.
I mean, it gives them an option to
Yeah,
do something different
absolutely.
besides murder. And if they can pursue this,
If we don't make a finding that say in this particular case, if we don't make a finding that might have some bearing on his future conduct with the public, then we couldn't put him on a probationary period.
But I think I would like to see to make a motion with his convictions, to put him on probation for 2 years.
And that's what we're doing. We're
Yes.
actually voting today for all three
For all
of them,
of them
unless
to
the
be
board
on-
wants to do it
Okay.
differently. Yes.
Well, I'd like to make that motion.
Okay.
well, I mean, yeah, at the very least, he needs to be
Yes.
on the same, but you're saying we have the option to deny it if we wanted to because of his felony.
You've always had the option to deny anyone a license if they had a felony conviction, I think, within the last 3 years? Because the law has changed for barbers, it's no longer the ability to deny just because they have a felony conviction.
Right.
You have the ability to deny if their felony conviction bears on their ability to practice as a barber. So, if you want to put him on probation, you still have discretion to do that, so long as the board votes, makes a finding that the thing that he is convicted of bears directly on his ability to practice. Does that make sense to you?
That connection.
That's just really hard to determine, I think. I mean,
Well, and the key, I apologize, is this board has never denied
Right.
based on the felony. So I don't know that it's going to change the outcome. You just have to consider it different if you were wanting to deny. You would only deny those that affected the industry. Does that help?
right. If it said attempted second-degree murder with a pair of scissors, I might be like, whoa.
Yeah, yeah.
I'm sorry, I'm not trying to make light of it, but I just,
Well, I mean, it's up to the board's discretion. This bill didn't come with factors to consider. They're still leaving that discretion up to you. I mean, I could probably make an argument for a lot of convictions bearing on somebody's character and fitness or it's not character, but on somebody's fitness to practice. And I could probably also argue the other way. This is discretionary. So if you think that it doesn't have anything to do with him being able to practice, then we can't put him on probation. But if the board discusses and says, no, we think that does have to do with his ability to practice and interact with the public and be licensed by this board, then you make that finding and then you can put him on probation. or deny him, but more likely this board goes with probation.
I just kind of made the motion for.
Okay, so we have a motion that we determined that that's going to be a factor.
That's true, yes.
Do we have a second?
We have to just vote on this one? Or all of
You
them?
have to vote on, you have to make a finding, so you have to vote on whether or not you think this conviction has to do with him practicing as a barber.
Vote on that now, then?
Yes.
Okay.
I'm just trying to.
So
on
we
that
have a motion
motion.
that this conviction has a impact on his ability to practice as a barber. Do we have a second?
So therefore, we're putting him on 2-year probation?
That will come next.
Oh,
We have to do this step
Okay.
before we can do that.
all right.
I'll second it.
Oh,
Yeah.
So we have a motion and a second. All in favor, say aye.
Aye.
Opposed? Motion carries. Now, we get to vote on the,
I think
On the
all
probation.
3 of them should, I'd make a motion that we accept with a signed agreed order and a 2-year probation.
Second.
motion and a second. Any questions or discussion? All in favor, say aye.
Aye.
Motion carries.
Thank you. Okay, we are on for, to our applicant, our international applicants. You have on your iPad an application to test for an esthetician with hours from India for Sridivya Ambala. Ms. Ambala has provided translated diploma and a letter from the principal stating that she had completed 1,428 beauty therapy hours. These were completed between 2014 and 2015. So she would be missing roughly 80, 70 hours. I will let the board review and
License, her app is marked for esthetician.
is marked, yes, esthetician, I apologize. Did I say, oh, I said esthetician. Yes, so she has the 1,428 hours, which would be plenty for the aesthetics license. Our applicants complete the reciprocity, as we heard many of them this morning.
So she's asking to sit?
To test.
To test. Yeah, she has a Cedesco exam, so as long as her English is good, she should be fine on testing. I would make a motion to approve.
Second.
We have a motion and a second to approve. All in favor, say aye.
Aye.
Motion carries.
And this is to test. We're approving her to take the exams. Thank you. Next, we have an application for a manicurist license, and this is also to take the exam. These are hours from Vietnam for Linh Nguyen. Mr. Nguyen has provided translated documents and a transcript. The application has manicurist circled. However, the documents show he completed a total of 2,000 hours, which covers the cosmetology program. And the detail of the hours are found on page 104. Based on those documents, the consideration is actually for a cosmetology exam.
Which one is he requesting?
He actually checked on the application on page 101. He has checked manicurist. Looking at the documents provided, more specifically the transcript of the documents on page 1, they are actually hours in cosmetology. We were unable to reach them for further details. We can approve for the manicurist. We can, based on the review of the exam information, you can decide to approve for cosmetology.
He's just requesting to test.
Correct, with international hours.
I would only feel comfortable approving him for the test that he's requested.
Manicure. And if not, obviously, he will come back and say, I checked the wrong box.
Second.
We have do we need a motion on
Making a
this?
motion
The motion,
to
yes.
approve this gentleman to test?
Okay. We have a second?
Second.
We have a motion and a second to approve. All in favor say aye.
Aye.
Motion carries.
Next on your iPads, we have a presentation for a manicurist with hours from Vietnam for Thang Quac. Ms. Quack has provided a translated diploma and certificate of completion showing 714 hours received at World Nail School in March of 2016. The board has received several documents from this school, and at the June meeting, the director was advised to check with an agency or find an agency that would be able to evaluate the authenticity of these documents and others that we may have in the future. The concern was that several of these documents were coming from the same school, shared the same home address, same telephone number. An online search at that time did not find any information on the school. The board office worked diligently with legal counsel and the contract division to start this process. The conclusion from legal is that in order for the board to recommend authenticity of documents, there needs to be a full procedure involving an RFP, a request for proposals from companies that do this. And at this point, they would advise us to actually put this through the rules so that if the board decides to go down this, we are consistent and all international applicants have to go through that process. And so with that in mind, the board has the right to deny these applicants or approve them to test. We went ahead and searched the school one more time. I actually handed that over to someone else in the office to just look as deep as they could. They were able to find on your iPads, you have on page 112 and 113, online information with what appears to be the school. I have since spoken to a couple of individuals. We've delayed probably 5 or 7 applicants from the school. And originally, we did approve several to test. It was as the documents had the same phone numbers and address that we were hesitant in questioning. So at this point, legal counsel's advice is that we look at our rules and decide as a board if we want to request this verification eligibility process of all international applicants. It leaves us with, for this individual as well as the others, accepting the documents as is and putting them through to test, which would safeguard the public.
But
Safeguard the public if they pass the exams.
if we request information on a particular school, we can't just do it for particular schools. Every single international applicant.
Correct.
That we receive.
Correct. And we would go through the rules to do this. We'd establish a process to evaluate documents. A lot of states do that. Others, like us, put them through to test or just evaluate them the best they can in their offices. So it's a little bit of everything. But as the contract division started looking at this, their recommendation was that we can't just pick and choose which ones we don't think we find enough on. We're going to have to do it with everyone.
What's your recommendation on that?
I think where we stand at this point, putting them to test, which was, what we've been doing, if they can pass, it gives us that piece. If not, I don't think we can do anything else at this point.
Can we revisit this if we see more of these coming through?
Yes, we can always revisit, and I asked specifically that. The board can deny if they're uncomfortable. It's a hard line to know whether it's the same phone number and same address because they're all family members or helping each other out. That's very possible.
Didn't we have the World Nail School come up before, and it was discovered that it wasn't even open?
Like I said, we actually looked for it online and didn't find it. That's why this time I presented the documents that we found online. They actually do have, I believe, 2 campuses according to the online information we found now. So in a deeper search, they've got a web page. That doesn't obviously prove that it really exists, but at least they've got an online site that we could find. If the board approves, the 5 or 7 that we've delayed would go through and test the same way. If we're basically approving international applicants based on the documents to test, and then we deal with it within the rules. If the board is not comfortable with this school, you have every right then to discuss that now, and we wouldn't be accepting those documents.
How will we know if the school really exists besides the website?
But with any international school, we really don't. It's a risk we have. The wonderful thing about living in a state that is growing consistently and brings in people not only from other states, but internationally, I think this board has seen a big increase in our industry. It's probably the board that feels it the most. And there's definitely people coming in from other countries, and I'm sure their documents are questioned, many of them because of that, have them translated, have stamps on them. We don't know that those schools really exist.
Especially from this particular school, if, never mind the World Nail School or whatever, if someone was filling out an application that's supposed to be true, the name of high school attended is Vietnam. So, I mean.
What are the likelihood that
Why
7
would
or
you-
12 people will come from the same school in another country?
But I'm saying, even if she didn't go to this school, and why is she saying the name of the high school is called Vietnam? That doesn't even make sense. And that she completed 12th grade.
Their schooling is so different than ours, too.
Well, but
It's very
she could
diverse.
say it's different, or I went to, Ho Chi Minh High School or whatever, but that doesn't even make sense to me. So that makes me question whether any of it is truthful.
The diplomas we see, we have them translated and stuff, and a lot of them just say Vietnam. They don't say the town or anything on them when we get their diploma.
I feel like that's good
It's
enough.
kind of par of what we get from them.
Okay.
But if they can't pass the exams, then
Well, that's
we
true.
know-
I just,
That's
I
our
mean,
safeguard right
it seems
there.
like the high schools would have different names, though.
If I'm the testing company, I'm like, yeah, test.
But in the school, we do see a lot that just
Okay.
has Vietnam. It's really different.
Okay.
I think that we have denied before because we couldn't find the school, but now the school is found on the website and test and pass. That's all we have.
Do we have a motion on this?
I'll make a motion for her to test both parts of the exams as Tennessee.
Second.
Motion and a second to have them test. All in favor, say aye.
Aye.
Motion carries.
Thank you. So moving forward, this school will be considered like any other international. You all will see the applications. We will put through the others the same way to go ahead and test. And then on the next round of rules, we will definitely consider whether the board wants to pursue or not the authenticity of documentations, I guess is how we'll refer to them.
Just as a side note, Roxana, anyone that comes through internationally that has that Sedesco diploma, you could approve them. I mean, they wouldn't have to come before the board, would be my feeling. That's a very stringent diploma to achieve, much higher standard than any of the state schools.
The board's comfortable with that. I can look for that. We don't see it often.
No, you will not.
I can say that for sure.
There are only about 7 of us in the United States that actually have obtained that diploma.
I appreciate that. Thank you. Okay, next we have an application to test. This is for a master barber license with hours from Puerto Rico, Mr. Eduardo Rios. Mr. Rios? Si le hacen preguntas, me lo aprieta, ¿ok?
¿Me va a traducir o qué?
Thank you for coming in, sir.
Okay, Mr. Rios has his documents on the iPads for you. He's appearing before the board to answer any questions you might have. His documents and schooling are from a school he attended in Puerto Rico. He has 1,000 hours completed in September of 1998. In 2003, he completed an additional 236 hours. And there's another diploma or certificate that says 450 at a night school. So I will let you ask any questions. He is asking permission to take the exams to obtain his license. He is not licensed in Puerto Rico, so this would be his first license.
I didn't get all those numbers. What is the total on that, Roxanne?
1,000 is in the first school, and then he's got a night school that has 450 hours and 236. So he would have the needed hours that we need if we put him through to test.
this is for written and practical testing?
It would be both, yes. And right now, the exams are only in English for the barbering.
Speak English?
Okay.
Do you read
Are you
English?
comfortable with this written test?
Well, he can take it in Spanish, right?
I can do it. Yeah, I think I can do it.
Based on our last approval, I make the motion to allow him to sit for the test.
Second that.
I'll second it.
All in favor, say aye.
Aye.
Motion carries. Thank you for coming down.
Good luck to
Good luck.
you.
Do you have a job lined up?
I've been cutting hair for 20 years and trying to take the license, in different schools, but, this is the opportunity.
Good luck.
Appreciate it. Our crowd is thinning down.
Hello.
Thin down.
We must be boring.
Do we want to keep going? If the board needs to take lunch or want to take a break, let me know. We will probably have at least a couple of hours, hour and a half.
I need lunch, y'all.
Okay. What, break?
Why don't we take a break now for lunch, and we'll be back
You going to
in
the market?
45 minutes?
Oh.
Hour, 45 minutes?
1 o'clock.
Hold on just a minute.
If I could interrupt the board.
Go right ahead.
We have one applicant that has an attorney. Is there any way we could skip to
Sure.
that piece? Yes,
Sure.
absolutely. Thank you. Give me a second to point you to the right page on your on your iPads. It is under the miscellaneous section.
Well, Roxana, we can get through let's get through this section, and we don't need to break right this very second. Can we get through this in the miscellaneous requests?
Oh, okay. Yeah, it's only two.
Yeah.
Perfect.
Will that work?
That works, yes. Okay, now.
I think we've got one more international applicant. Sorry.
Thank you for letting us know. Okay, next on your iPads is Ms.
Oh.
Batel, Jugrati Batel. She was presented to the board previously at the May meeting, marked on her application that she was wanting a cosmetology license. Let me see if I can, what page is she on?
120. 120?
120. So she had marked on her application cosmetology, when in fact her hours, her experience, her knowledge is all within aesthetics. If you look at some of the certificates and diplomas, they're confusing. They do list both things, but most of her information, her awards, her practice is in bridal shows, makeup shows, that kind of thing. She is asking the board and prepared a letter. 122 is her letter asking the board for reconsideration so that she can test in aesthetics. That is the license that she's interested in.
All she likes is 50 hours, right?
No, she has more than enough,
She got more.
according to her different diplomas. I think I took out half of them. They're a little bit different than what we have. She had marked cosmetology, and that's on page 123. Her letter on 122 tells us kind of her experience and what she's wanting and what she's more really used to doing.
She has enough hours to test as an esthetician,
She does,
correct?
yes.
Make a motion for her to take the test.
Second.
We have a motion and a second to have her take the tests. All in favor, say aye.
Aye.
Motion carries.
Thank you. Okay, so we've got our next, under miscellaneous, we're going to take care of one before the board breaks for lunch. And this is a request for reconsideration of a reciprocity license from Michigan for Ms. Batal Mohammed. On your iPads on 132 is a letter from her attorney, John Dana Slater. We're going to make sure that he gets a chance to answer any questions the board has. I will turn it over to Laura so she can fill you in. The documents that you saw in her presentation for her reciprocal application are there on your iPads as well.
Thank you for coming in, sir.
you a little background. Ms. Muhammad had applied for reciprocity, and at the time that her application was made, because of her proximity with other issues that came before the board, it was our belief that she had previously been practicing unlicensed. And so at that time, legal made the recommendation to deny her license. Some of the things that we relied on were an online profile, a Twitter account that we believed was hers, where she identified herself as a working stylist, and then also a police report from an unrelated incident where she was identified as working at the salon. Her attorney has written in a letter denying that online profile was hers, and also pointing out that the police report does not identify her as a cosmetologist, which is true. It just identified her as working at the salon. Roxana has been able to verify, though, that she did test and received a license in Michigan and has gone to school. So I'm not really going to make a recommendation either way. I think it is has gone to school, and whether or not she practiced unlicensed, but I believe quite a bit of time has passed since then. So, any other questions?
Did she attend the Paul Mitchell School here in Tennessee?
Yes, yeah, I think in 2007.
And went to Michigan specifically to take the test in Arabic? Okay. And do we have any of those test results?
Roxana has been able to verify that she did test and pass. I don't know
Okay.
that she has the scores, but I
Okay.
know that Roxana told me that she verified.
Okay.
So she also went to Lyle's school?
Yes, that's where she received her diploma. 2012, I think.
Oh, I'm sorry, but I'm looking at the state of Michigan, and it's saying she obtained her license by reciprocity.
We viewed a few Michigan applications with the reciprocal committee earlier. Michigan evaluates educational documents, and they will put applicants through. I believe, I don't have her applications to test here in front of me, but I believe when we presented her in May that we actually had her PSI exams. Michigan uses PSI. With their international applicants, they accept ours and put them through to test. The board has consistently asked for 5 years work experience, or we put them through to test. That's how we take our international applicants, so that they test in Tennessee as well.
Where was she before? They took the international hours in school and to the reciprocity in Michigan, so that was her first U.S. license.
Her first
Yeah.
U.S. license is the one in Michigan.
They were from ours here in Tennessee.
I believe
went to
so. I
school
believe it's
here.
because of the translator.
She went there because they have the
Because
test
of
in
the
Arabic.
Okay.
Michigan allows a translator to go in to the exams with you. Tennessee does not.
I
And
have a
so-
Michigan license, and it was pretty simple.
Yeah, I think the board, because of that, has been under the opinion, and we've recommended everyone to test because of that. Her hours are here in Tennessee, correct?
Yes. Your hours.
So this, when this came before us before, we denied it,
That is correct.
and it was for a cosmetology license?
Yes.
Call all the facts of that particular one, but I believe, didn't we?
I don't know that the board denied her. I'm not sure that the board even got into her education or testing. It was because this department believed that she had been practicing unlicensed in a shop owned by her husband, and that was part of the. And so at that time, we recommended that her application be denied because she had been practicing unlicensed. But she's coming before you again and asking that you reconsider her application to be licensed. And her attorney, I mean, they have, they do not agree with the evidence that we had used to say that we thought she had been practicing unlicensed. And I think now it's just whether or not I think if you want to consider her education and then ask them any questions about whether or not she had been unlicensed working or anything like that is sort of why they're
Be
here.
willing
So
to
it was
test
an
in
ethical
Tennessee.
concern about her practicing without a license that led the decision to be made for denial in the past. Okay.
Should she be able to test it, our state laws?
The board can recommend testing. That's
Yeah.
what we do with all Michigan applicants. The issue you're going to run into is the language. And you can ask her yourself, I don't know how comfortable she would be testing in Spanish. The board today, I think, had 3 or 4 applicants from Michigan. All of them had to test.
They don't offer the testing in Arabic here, do they?
No.
Okay.
Translators, I believe she was able to have a translator in Michigan.
Pay for a translator herself? And through PSI?
No.
No, they wouldn't allow her
They
in.
won't let her?
Against our contract.
Was she practicing without a license in her past?
From what I understand, no. I think the board alleged that based on a Twitter account, I think that had something like 4 followers from 2012, or I didn't even see any posts. But Toole thinks it might have been her daughter that made a Twitter account. She said she doesn't even know how to work a Twitter account. And then there was a police report from where someone was, there's domestic assault, a violent domestic assault in or right outside the Oasis Salon. Batul gave a statement to the police, and they classified her as an employee of Oasis Salon in the police report, as well as a newspaper article. And that's what the board based as she was practicing unlicensed.
Was she an employee of that salon?
She was a landlord. Her and her husband were the owners.
They own the salon or the building? Okay. And how long have you owned the salon?
Since 2007.
2007. Okay. And so then you're just now asking, 9 years later.
Take the practical part?
The board could definitely, for the language issue, we have waived the theory. If the board recalls, we've had several individuals that had struggled with the language
Right.
when both were recommended, and they've done much better with the practical.
Practical part.
Ms. Vice Chairman, and to answer your question about how it took 9 years, I think there was, they had 8 people working at the salon. It was successful. And recently, there's been some issues to where they had to shut down the salon. They're still paying rent, waiting on license, not able to generate enough revenue to employ other people. So the 8 years, and now wanting to do this is based on necessity.
How was the salon shut down?
It wasn't shut down. They had to close it until someone was licensed. Apparently, someone went in there and said that the shop license had been expired. But there's a dispute whether the shop license is expired.
Where is the shop?
Thompson Lane, 24,
Thompson
I'm
Lane.
sorry.
Here in Nashville?
Yeah.
Yes, right up Thompson Lane.
Did an inspector come in and find that there was not a shop license?
No, this was part of multiple cases that were presented to the board, and the board voted to revoke the shop license based on the activity of Ms.
License
Mohammed's
activity.
husband. She was never really implicated in those issues. But because of that, I understand that, and Roxana can correct me, he had agreed to sell the shop to maybe
Different young lady.
matter, but that's why the shop had been closed.
Due to unlicensed activity?
It was a very complicated issue.
Okay.
It was the multiple cases that came before the board where we thought her husband had been involved with the selling of licenses.
I do believe I remember some of the facts from that particular time.
And to be clear, Ms. Muhammad was not implicated in those. She wasn't named as anybody in any of those cases, but that was one of the reasons why when she first came before the board, it was right when all of that was happening, and we had some concerns. But those cases are settling. All of that is kind of reaching its conclusion, and she does have the schooling, which is why I'm not really recommending that you deny her. But because of my prior recommendation, I'm just not going to make one.
I think, to paraphrase the attorney's, the state's attorney a little while ago, at that time, I believe we were looking at this as a possible case of that straw man ownership. If that's the one, I'm thinking of the one correctly, that we might have thought there was some multiple things going on with those. So that could have played a part in the time. Again, I'm reaching back in time. I could be mistaken. But if she has...
I would be comfortable if she took the practical part of the state board.
Have you been working? Have you been working?
I work in a staffing company.
Staffing company.
Say it again?
She works at a staffing company now.
Oh.
She's got her whole entire existence when she lived in Iraq. She has experience doing that.
I agree with you about the testing.
Make a motion.
I mean, I'd like to find a way to get her licensed.
Right. Yeah. To get her to work. Make a motion for her to take the practical part of the state board.
I'll second.
We have a motion and a second to take the practical. All in favor say aye.
Aye.
Motion carries.
Walk her through the next step. Thank you, board. If you want to take it, go ahead and stop for lunch. I'll walk her through what she'll need to fill out upstairs. Thank you very much.
Good luck. It's 12:15. Why don't we try to be back here around 1? Is that okay? We'll be in recess.
No, that's 12:59 for you.
We are back on the record. Thank you.
Well, we know how to clear a room down.
This meeting of the Cosmetology Barber Examiners Board is called back to order.
Thank you. And on your iPads, we are on page 145, but if I could, I'm going to ask the board, I handed out paper copies of a school application. What did I do with mine?
Where they at?
Okay, so this is not on your iPads. This school is for, Ms. Turner is here in person, and I'm glad she came, so she hung in there as we did this. I had not received everything timely, and when I left a message, she and I crossed each other, so she didn't know that I wasn't gonna present her, so we've gone ahead and printed paper for you. I've handed out all the copies, but I don't think I need to see it necessarily. This is the school out of Memphis that has been approved to do the apprenticeship only for natural hairstyling. So it's our first specialty schools, as well as it's the first one that was not gonna have any floor space. So as time progressed and she got students that were very interested, and she'll fill you in on her success story, it has gone very well for her. They've been approaching her wanting to do it faster and wanting the floor time on the school, which is what we always, when we discussed when we were looking at the rules for the cosmetology board, is that schools probably still want to have the two options, because you're going to have students that want to do it the traditional method and those that want to do it just through apprenticeship. So that's what she's found. So this is considered a change in location. She's had to get the space, I believe, right next door to where she's at. So we would actually need to do an inspection, because the first round we didn't. It was strictly classroom. So she'll answer your questions, but we've got a floor plan that you can review, information on the addition, and it's the same curriculum, just now offering the students to be able to do the 150 hours traditionally in the floor space there. Congratulations.
We're glad you've had some success.
I'm sorry, I didn't hear you.
He said, we're glad you've had some success.
Thank you so much.
It's way better than our morning.
I know, I kind of got sad this morning. But thank you all so much for adding me to the agenda. As Ms. Gamusio said, we do just have just a few students that are interested in just going through the program. But what we've talked to those students about were they have to let us know on the front end if they want to do the apprentice or the traditional. And we only, we have a few that want to do the traditional. But for our students that are in the apprentice program, we have partnered them with salons. They completed the 150 hours. I'm going to turn my hours in today for those students, and they'll be ready to test, and they already have a salon that's waiting for them. So I'm excited about that. We prepared for 12 students. We ended up getting 20 students. Good. Yeah, so they're all paired. So, yeah.
So you grew so much, you need to have inside space now.
Yes, yes.
Okay, that's a good problem.
On the space, on the floor plan, we have 6 stations, but we had to go in and take one out because I just wasn't comfortable with the space, and it's the 2 that are on the back wall. One of the spaces, the way that they sit, it was just too tight for me. And like I said, I work in a salon as well, so I know the need for comfort and to be able to move around your area. So we didn't want to have it, too much, stations.
Dryers, 2 shampoo units, and looking at 6 stations and chairs, or did you say you took 2 out?
We took 1 out, so it's gonna be 5 stations. Cosmo Prof had a really good sale, so I went overboard on the stations.
There's no minimum space requirement on that one, is there, Roxana? For square footage?
Oh, I'm sorry. 1,600 square feet for these, none at all. For the specialty schools, we leave it alone depending on how big or small the schools want to do. The only requirement is the 5 student enrollment agreements, and she'd supplied that originally, so she still has those.
Okay.
We're still encouraging the students to do the apprentice program. We really want as many as possible to go through that program just so that, it could be successful. So for those who we just can't get, we want to be able to have space. Or for those who go out and something happens where they have to come back, we want to be able to have space for them.
Everything looks good to me.
Sorry.
I think everything on our plan looks good.
In your enrollment agreement, did you have a change for the cost for the in-house students? Okay.
Then we also added, because at first on the initial enrollment agreement, we only had apprentice, and then when we went back and did it, we added apprentice and traditional.
Okay. I see.
I make a motion to accept.
Second.
We have a motion and a second to accept and approve this. All in favor, say aye.
Aye.
Motion carries.
Thank you. Congratulations. We'll send it to the
Much
inspector. Thank you very much. Okay, we are going to skip, if we could, because we had 2 applicants waiting, and they took a lunch with us, but they're ready to be presented to the board. If you can turn your iPads to page 175, I have it labeled as revoked licenses. I think also Attorney Glandorf will answer any other questions you may have. We're going to start with an application. Just a second. This is for a request from Mr. Taiwo Anderson. He is asking permission to continue testing as a master barber. Mr. Anderson is here before the board to answer any questions you have. He completed his hours at International Barber and Style in 2002. However, he's failed the Tennessee exam, I believe, about 20 times. In 2012, he obtained a master barber license by reciprocity. An audit of the files found the license to be fraudulent. In May of 2015, a complaint was finalized and Mr. Anderson's license was revoked. The board has the consent order and all the documents for your review. I'll let you take a minute. I'll make sure that he's ready to answer any questions, and then Tony, if you need anything to add, we'll proceed. If they ask you anything, just make sure that's right, okay?
Thank you for coming in, sir.
Sorry, Mr. Anderson. Again, my name is Tony Glandorf. I'm the Chief Counsel for the Regulatory Board's Division of the Department of Commerce and Insurance. I wanted to speak on Mr. Anderson's application to bring some of it to light and to my understanding of the application process. I actually was the litigating attorney originally on this case, and it was transferred to another attorney at a later time before the final outcome of it. But as we obtained this case because there was an audit that was done of records several years ago, and during the audit of the records, we found that RBS, the Regulatory Board system for storing information, indicated that Mr. Received a license, and the system said through a reciprocity means, and it said from Washington. So I myself actually contacted the state of Washington, Washington D.C., and neither had a license ever issued to Mr. Anderson. So we couldn't understand actually how he had a license, and my understanding is that his actual license previously provided was actually a barber instructor license, is one that he was issued. So because we could not obtain the underlying documents as to how he was licensed, we went through the process to have the license potentially looked at being revoked, not for anything that Mr. Anderson had done that we had information on, but because of the fact that the system provided him a license and we can't find out why it gave him a license because we didn't have an underlying information on that. So at some point in time, I sent one of our investigators out there, Miss Lori Wilson-Weaver, to speak with Mr. Anderson, I believe at some point in time. And because we knew that he had taken the exam roughly 20 some odd times is what we had and had not passed the exam yet. And I know that Mr. Anderson provided Miss Weaver with some recent documentation as the last, I believe, exam that hadn't been passed. So based on that, we were stuck in the situation where we had somebody who we know hadn't passed the exams in this state or any state, but actually had a barber instructor license. Because of that, we filed a notice of hearing and charges just to have that license revoked. And the language in that order doesn't allege any actual fraudulent activity on the part of Mr. Anderson, but just that the requirements for licensure had not been met. And because the requirements for licensure had not been met, then that gives us grounds for revocation of the license. We went through some process and procedures to try to get that license revoked in a different method other than a formal hearing, but we had difficulty actually getting in contact with Mr. Anderson at some point in time until we had our investigator come out there. So that's why the license was revoked, and I had stood firm years ago saying that I would not have an issue with Mr. Anderson receiving a license in the state of Tennessee, and that I would actually come before you to say that we don't have any information of any fraudulent activity going on part of Mr. Anderson. We don't have that, but so long as he actually can show that he actually passed the exams in the state of Tennessee and actually meets the requirements for licensure as a master barber. So I wanted to give you all that background on there because he was previously had a revoked license, and that is why. And it's my understanding that he has not passed the exams at this point in time, but I leave that up to Miss Roxana to confirm that, and then I believe you all can hear from Mr. Anderson.
So at this point, if the board is in agreement, you would accept the hours that appear to be legitimate from 2002 and approve him to test again. And he can answer any other questions that you might be asking for this time.
Hours from 2002, there wouldn't be an expiration on those.
Right, because he finished them, and he's been testing, or at that point, he
He's been in
started
the testing
the
process
testing right
since.
there, yeah.
Okay.
And that's the ask today?
Pardon me?
That's the only ask today?
Yes, because he has no license that we are aware of in any other state for him to come in through reciprocity. It would have to be acknowledged that those hours are still perfectly good, and if the board's okay, then approving him again to test.
How did you obtain your license?
I don't know. I just end up getting something in the mail and thinking I done passed because I took it so many times. You know, I deal with I got a football organization. I deal with the Antioch community, so you know, I was taking the test so many times, doing so much in the community of Antiochs, and I'm thinking I passed. So you know, I just took it like that, and you know, I guess it was something came through the system but was wrong. My first name is Tayo, my middle name is Abdul, my last name is Anderson. So I don't know.
Did you ever work as a barber? Do you
No,
work?
sir.
What about a barber instructor?
No, sir. I'm trying to be a master barber once I, take the test and stuff.
This is just for, I guess, talk's sake. Do you know what your score was on the last test that you took?
It could have been maybe in between 58 and 62,
Why do you think that you couldn't pass the test?
Just got to be more focused, stay in the book more. During that time, it's a new book out now, so it's a lot of new different things dealing with chemicals and relaxers and stuff like that. So,
So you're focused now?
Yes, ma'am.
I motion him to take the test.
I second it.
We have a motion and a second to approve him to take the test. Is there any other discussion? As a teacher, a school owner, I have to ask you, is there a particular part of it that's so difficult for you? 20 times is a lot of times to take that test.
Money.
It's a lot of money, yes.
Yeah. Really, the chemicals and stuff, I'm basically like just cutting. When I was going to school out there, was a lot of difficult things going on, dealing with the teachers and, I guess they had so much to do. So we really went just in that book work back, in 2002. And once I finished, trying to take the test, it was sort of difficult. So, I think once I get ready, I get with somebody and just sit down and get focused with it.
BSI gives you a good printout in there on what chapters to study that they're going to ask you questions out of on your list for your written test. It's broken down. It tells you exactly which chapter it comes from and what answers you need to be looking for. So maybe take that as your guide and kind of study from that really good.
To add too, I can't think of the book, but someone came before us at one time who had put a book together like a
To pass the test.
lay terms.
Amos, I think, was his.
Yes.
He handed out this book, and I'm sure you could search for it online, but I would think that would be a great study guide, just, kind of in simple terms that it's easier to understand, or it was for me when I read it.
Mr. Anderson, we still have to have a vote before we do this, but I have to applaud your tenacity, if nothing else. 20 times take that. You can feel free to contact me at my school if you're so inclined, and I'll be happy to help you with that as much as I can to get you prepared. Okay? Okay. Do we have a motion and a second? All in favor, say aye.
Aye.
Motion carries.
Thank you, sir.
Thank you a lot.
Congratulations. Okay. No, I have everything. We'll put you through. Thank you. Next on your iPads, we are on page 186. This is also a license that was revoked. This request is for Mr. Peter Nguyen. He is asking permission to continue testing as a manicurist. Mr. Nguyen is here to answer any questions you have. He is a gentleman that did not make it. He came by the board office, and his girlfriend was probably 8.5 months pregnant. So Friday, she went into labor. But so that we don't skip one more, we're going to finish with him, and then the applicant that is here will be able to come up. So he has a license by reciprocity from Texas. Many complaints have been open, as the board is aware, through schools in Texas that weren't following the right steps to give hours to individuals. The board has approved revocation orders on many of them. In speaking with Mr. Nguyen, he has the complaint in his hand. He and I had a conversation. He was not ready to surrender the license. However, he did say that he, in fact, didn't get licensed by going to school in Texas. And so after having those conversations, he agreed if there's any way that the board would allow him to continue testing, he was going to go ahead and sign over his license. And so that would close the complaint and then go back to testing. He explained to me that the reason he went through the process in Texas is because he was failing the exam here. So on your iPads, we have his education completed in 2003 at Tullahoma Beauty School. So he has the hours here, and he did start the testing process with PSI. He actually tested and failed 19 times between 2007 and 2011. And so his logic in speaking with me is that the language is going to make the difference, and he should be able to pass the exam. Given, like I said, that his girlfriend was 8.5 months pregnant, we had the conversation. His plan was to give up the license, and if the board approves him, he would be able to go and test. So similar to Mr. Anderson, his hours are legitimate. He got frustrated with the testing, found a way to get this license, and so he's asking the board permission to continue testing. Your iPads is earlier in the complaint committee, Laura explained a little bit about the complaints against Texas. Everything you see blanked out is because it's a different applicant, and so we covered everything and opened the cases against each individual person.
Asking to take the test again?
Asking because he has a
19
revoked license
times.
in history. He's got legitimate hours in Tennessee, and so he's asking to be put through the test again.
Now we offer in
We do
Vietnamese.
in his case, in Vietnamese, yes. We do not for Master Barber right now in anything but English, but we do for manicuring, aesthetics, and cosmetology, and he's pursuing his manicure's license.
I think we'd have to, because we just did the one right before.
Right.
It'll be the same all the way across the board, so I'd make a motion to approve him to test.
I'll approve. I'll
We have a
second it.
motion and a second to approve for testing. All in favor, say aye.
Aye.
Motion carries.
Thank you. And in his case, he will have to give us the license back and surrender it before he can continue. Next, and the last one of these, I promise, is an application, a request for the board to approve him for testing. This is for Mr. Phuong Than Do.
What page?
196.
If they have questions, you'll press this button, okay? But they have all this.
Anna?
His application starts on page 196. September of 2011, Mr. No obtained a Tennessee manicure's license through reciprocity. An audit at that time revealed that his license was obtained by fraudulent means, and a complaint was opened. In January of 2014, Mr. No signed the order to revoke his license. In December, he completed 621 hours, and the proof of the hours is on page 127, at Lyle's School of Hair Design. He has been testing with PSI since that time. June 29th of 2016, he passed the practical exam and is now ready for licensure. So he has the hours in Tennessee, and he has passed the examination. He's coming before the board because anybody that's had a license revoked needs to appear before the board. And so he's actually ready to be licensed and start doing, follow all the steps. The board has his license that he turned in upon as part of this revocation process on page 204. The last page, I think, is just a quick recap of his old licensing file and part of the cases that were within that audit scheme that had some fraudulent licenses. So he is asking for his actual license at this point, if the board agrees.
So he did all the steps to correct all the
He's
mistakes.
finally passed the exams, yes.
I'm motion for him to get his license.
Second that.
Before you second it, I move that we let him have his license under a year probation.
Have that motion yet?
Okay.
We have a motion on the floor and a second.
My motion is for him to be licensed. That's what I originally said. But I do agree with the 1-year probation, if I can add that in there.
That permissible?
Roxana, can I? And then come back.
Or you can make an amendment on your motion. Or you can make an amendment on your motion.
I make an amendment on the motion.
You
I'll
would
second
have to
that.
Yeah, there you go.
Thank you. We have a motion and a second. Is there any other discussion? All in favor, say aye.
Aye.
Motion carries.
And I'll explain to him, and the probationary period will be with an agreed order, similar to what we do with the felony. If anything comes up, then we have a clause in there. Okay, thank you.
Reading through this.
What's that?
We're gonna be here till dinner time tonight. Thank you.
You're welcome. Thank you very much.
Bye.
Good luck.
Good luck to you.
Thank you. Be safe.
Okay, let's not forget our folks that passed the 6 months. We're gonna go back, and I'll give you the page number in a second.
$44. That was a complete guess. And it was it.
Okay, these are applicants that have gone past the 6 months for their license. First is Mr. Jeremy Ames. Mr. Ames, if I can find him, it would help an awful lot. Got it. Okay, we are good. This is a request for a waiver of Rule 0200-1-.10 to obtain a license within 6 months after passing the examination. Mr. Jeremy Ains passed his Master Barber practical exam on November of 2015. Under the barber statute, the applicant must reapply and take the examinations if within 6 months they've not obtained their license, and after having been notified that the license, that they could obtain a license. He took his exams while he was incarcerated and is still serving time at this point. This is the reason for the delay in him requesting the license. If it's okay with the board and you approve him, he would be able then to obtain his license.
Motion that he can obtain his license.
We have a motion and a second to approve. All in favor, say aye.
Aye.
Motion carries.
Next, we have a request of the same waiver, 0200-1-.10, is requiring an applicant to obtain their original license within 6 months after passing the examination. Mr. Carlos Palmer has appeared before the board for an extension of this same rule. At this time, he has provided medical records of past occurrence, as well as right now still suffering with PTSD after serving on the Gulf War between 1994 and 1998. He struggles with following through on the details. That is the same reason that we presented him the last time. He has stated he passed the exam, and if you notice on the exams, it's actually a reinstatement exam. So he passed it in March of 2015. I'm hopeful that if he gets the letter this time, he can follow through with it, but that is one of his struggles. He is requesting the board permission to try again to get his license.
Does he just need to do, mail it back?
At this point, if it's granted, it's mailing the application with the fee. So at this point, at least we've got the documents. If the board agrees, then it's going out the door. I don't know that, then he'll still have to renew every 2 years and that kind of thing. He's dying to be able to work as a barber, but struggling with some of those things.
So we're just granting him another extension?
Yes, and the extension would actually give him the license this time. The last time we granted him the extension, he hadn't even asked for it. We hadn't gotten the paperwork. He presented his medical records, and then finished the examination and applied for the license. But of course, that was in March 2015, so it's been a while. I think he appeared before the board that first time he was.
Part
2.
Can we send him a note to really encourage him to get this done, because if it keeps coming up?
Right, this application is actually with the fees and everything. So if we approve it, the license could go out by Thursday potentially.
I would make a motion to approve it.
Second.
We have a motion and a second to approve. All in favor, say aye.
Aye.
Motion carries.
Next, we have a request for Rule 0440-1-.10, requiring an applicant to obtain their original license within 6 months. This is within the cosmetology statute. Ms. Haven Underwood passed her cosmetology practical exam in September of 2015. Under the cosmetology statute, if the applicant does not submit their paperwork for a license within 6 months, they must notify the board of good cause. Ms. Underwood submitted a letter explaining that she had complications with her pregnancy. She also submitted several medical documents to support the pregnancy and issues afterward. I kind of went through based on the date and pulled some out, but she provided plenty that covers the dates from September until, I believe, all the way to March 2016. So she's asking the board approval. This would be the same thing. If the board approves, her license would go out.
Make a motion that we approve her license.
A second.
We have a motion and a second to approve the license.
Thank you. Mr. Fingers.
All in favor, say aye.
Aye.
Motion carries.
Request for waiver of 0440-10-.10, requiring the applicant to obtain the original license within 6 months after passing. Ms. Ashley Frey passed her cosmetology practical exam in August of 2015. Under the cosmetology statute, they must reapply for examination within 6 months unless they can provide good cause for the board. Ms. Frey submitted a letter from an instructor, and that is on page 166 on your iPads. And the instructor on her behalf is explaining that she underwent medical treatment. From the dates of the medical records, it is clear that between September 2015 and February of 2016, she was dealing with various health issues. She's requesting the board waive the requirement to retest, and if this is approved, her license would go out.
School, correct?
Correct.
When did she take it? What's the date?
She took it in August of 2015. Records for the medical documents are on the right-hand side. In September 2015, she started with health problems. And this goes through the beginning of 20.
Motion that we approve her license.
Second.
We have a motion and a second to approve. All in favor, say aye.
Aye.
Motion carries.
Licenses, and we are on page 206. This is a request for a manicurist instructor license. Mr. Cow took and passed his exams and is timely requesting his license. He thought he attended Pyramid Beauty School in Memphis back in 2015. When the board office audited his instructor hours, no hours were found under that school's license of their monthly reports. Other parts of the information that he gave us as well did not match up. He was handed a recent withdrawal document that is on page 208. And upon further having conversations with him, he did think that he got the dates wrong, that he attended school in 2014. Upon speaking to him further, auditing different records, we finally found in the August 2014 hours for Pyramid School, 306 hours submitted. This is back in 2014, and did find that he was on the report for instructor hours. He stated, however, that instead of pursuing and calling the board, he decided to go to another school in Memphis because that school has current complaints. That's all that I'll say to the board, but that school took him in and put him into test as opposed to reaching us or getting a withdrawal document or doing anything that would have been the normal steps. That is what flagged his hours. In talking to him and seeing these things, I don't think he did anything wrong necessarily. We finally were able to find it. He is requesting that his license be approved. It's clear from here that at least hours at some point were submitted for him. He tested and passed. He's ready to receive his manicurist instructor license.
Make a motion to approve.
I'll second.
Sure he's actually had a manicurist license?
Yes,
Okay.
yes, that he has.
We have a motion and a second to approve. Any other discussion? All in favor say aye.
Aye.
Motion carries.
Thank you. Next, we have a request from instructor Pamela Hurd for consideration for Miss Continue Education. Ms. Hurd has a very unique situation, so bear with me as I try to point her letter. Her letter is on page 211, and soon after you're going to see records of 2 different licenses within our system, which is the core system now. Ms. Hurd has a cosmetology license that goes back to 2006. In 2009, she obtained an instructor license and attended the 2010 seminar for instructors. She continued renewing that license, but didn't keep up with the continuing education because she moved out of state. Then something in 2014 happened, and I refer to that because on page 216 is the record of the second license. She attempted to obtain her instructor license back through reciprocity. And so at that point, that license was treated as a brand new license. So she got another cosmetology license, this one with the instructor piece. In April 2016, she should have renewed and did not attend a continuing education session. She confused and didn't realize or point out to anyone that she had the 2 licenses to keep up with. And so at this point in April, because April has passed, she is late trying to get that continuing education extension. The board can extend those one time if they ask for them timely. So she has a unique situation where she was attending continuing education when she moved out of state, and I believe her letter explains some of this. Had she realized that her license was up for renewal by April and needed to get the continuing education done, she probably would have asked for an extension on that or attended. I'm not sure how she didn't realize there were 2, but she didn't realize she was renewing and keeping up with 2 licenses.
Roxana, are y'all administratively pulling these licenses together now for her? Or
Yes, and more importantly, here's what happens. If someone just submits an application for a license, the system would recognize the Social Security number now and flag it and say you've got, another license. The issue that we have sometimes with cosmetology, and it's a matter of training as well, the department that takes in the money, because we don't, is that cosmetology has so many different ranks, discipline types. So you could have a manicuring license and a natural hairstyling license and an aesthetics license, and they're uniquely separate licenses. So the system, whereas for other professions that wouldn't happen, you'd have one and one only. For us, actually, some people do have more than one. So it would not have stopped her. I just don't think when she applied for the second license, and that one was issued to her in 2014, we were in a previous system, so no one caught that it was the second one. It could still happen, just very less likely now, because it flags that.
she's a resident of Tennessee now?
Yes, she's now in Tennessee. Her letter states that she would like to go back to teaching. But, you know, if the board doesn't agree with this, then she would have to take the instructor exams again. And I highly recommended that she pick the oldest license preferably and keep up with it, and we kind of consolidate the whole thing. But back in 2014, it wouldn't have caught it necessarily. And I can't tell that she's kept up with continuing education. So if the board agrees, then we can definitely hold back on renewing it as well and letting it go out until she attends a session, and we can go from there.
Guys who have schools, I mean, would you want an instructor that's had no current 2-year blank?
Not in my school.
She hasn't asked for a previous extension, has she? The
No,
one
she has
time?
not, because she moved out of state. So in essence, when that instructor piece went away in 2010, because she moved out of state, so we dropped that completely. When she came back to Tennessee, and she would have the perfect right, she maintained instructor out of state, and so she applied for reciprocity with that instructor informational, and we granted it. That gave her a brand-new license in 2014, which should have really just changed her old one to include the instructor piece,
Yeah, that makes sense now.
is what it should have done, yeah.
So do we know, she's saying that by the time we read that she would have taken hours in July. Do we know if she did that or not?
The session in Knoxville in July was in the middle of July, so she probably didn't attend that one. She may be referring to the online class that we had.
Oh, yeah, the online CEU class.
Yes, and so we don't have Ms. Gordon's list from the July participants yet, so hers hasn't cleared. But if the board agrees to accepting and considers this her one-time waiver, then yeah, we wouldn't let it go out until we see that she's attended one, because she definitely would have had a gap in continuing education.
But if she applied to teach at a school, no one would know that she hasn't really kept up with things for a couple of years. We would only know.
Actually,
She has to provide.
yeah, both licenses dropped the instructor piece because she hadn't kept up with them. So when that 2016 renewal that she paid money for went out, we took off the instructor part because she didn't meet it. So that's what flagged her. When she got it in the mail, she went, oh, where's my, neither one has my instructor piece, something's missing.
There's more to this than just missing the class and needing to extend it. It's the fact that she actually lost her license by not meeting the requirements. Is that pretty fair to say?
The instructor part of the
Instructor part,
license,
the
yes.
instructor part. She lost her credential.
I think in the past, we've typically granted the one-time exception. So I'm going to make the motion to go ahead and grant that.
We have a motion, do we have a second?
I'll second that.
And we have a second. All in favor, say aye.
Aye.
Motion carries.
Thank you. Okay, next we have a request from Mr. Travis Hughes. He's a master barber with Master Barber Hours. He has presented an explanation on page 219. He too is a little bit unique. While he was incarcerated, so he obtained 899 hours in the curriculum of barbering in 2007. Then while he was incarcerated, he was able to complete the cosmetology curriculum. And in October of 2010, he obtained his cosmetology license. Usually the crossover statute between the two, not usually, it specifically says you must be licensed in one to allow a school to have the right to accept that and teach you just the other half of the curriculum. So you would need 750 hours upon licensure. His is kind of the other way around. So he is asking the board to consider those 899 hours, which he obviously did take, and grant them because he also is a licensed cosmetologist. This is definitely unique. I guess the only thing I can point out is if we say no, he's going back to school, I don't know to learn what.
He's already had the
Because he's
courses.
already done it and then some, right, so,
You have to be licensed in one while you're doing the other, though.
correct. I get the whole, I didn't know what to say to him other than I need to present this to the board, so.
But he has actually completed the additional hours and required.
Backwards.
Yeah.
Not
Literally.
intentional, I'm
No.
certain that wherever he was incarcerated didn't open both programs. They're close enough that usually they go with whatever instructor they've got.
Totally different.
I believe I'm going to go with it. I move that we do that.
Accept his hours.
Based on the unique
Accept his hours.
circumstances of this case.
Yes. Even though they're backwards.
We approve them to test.
Yes. Even though they're backwards.
I'll second it.
We have a second by Mona. All in favor, say aye.
Aye.
Motion carries.
And very different things today. It's been diverse.
I hope we don't see again.
How many more pages do we have left, Roxana? What else are you going to throw at us today?
Didn't we say we wanted to be consistent? We didn't know we were going to have so many inconsistencies.
Have to skip again.
Okay.
So, there are some rule projects on your iPads, but before we address those rule projects, Tony actually is going to talk.
Right, yep. So, thank you. I wanted to address you all about some rulemaking that you have in process. You currently have in process, and I know that it's difficult to kind of keep them all separated because they all are kind of our rules. But last November, I believe that you all authorized a rulemaking hearing for a set of rules that would help what I guess would be equalizing fees amongst cosmetologists, barbers. And so that is in the process of being processed for a rulemaking hearing. Those rules, basically, part of them would increase fees. They would. That's not generally the issue. That's not an issue. That's not why I came to you. But there's a separate Tennessee statute that says anytime you create fees or increase fees, regardless of when the board passes them, and you would pass them in the future at a rulemaking hearing, they won't become effective until July 1 of the following year, so long as they're filed 90 days before July 1, which is roughly April. So when you all authorized those rules back in last November, it's our calculation near impossible to get them rulemaking hearing and filed and everything by April 1 or whatnot. So what that kind of brings us at is that no matter when you all pass them, they essentially wouldn't be effective until July 1 of 2017. We're looking at 11 months from now. So everyone in our legal division office has been contemplating what could we do to help speed that process up. And the issue is that this board has some fiscal issues, and so it would help speed up that process so that we could create, so that we could have the equalization of the fees and we could actually create higher fees for certain applicants. And we have it here. It's not that significant of an increase on an individual level, but when you multiply it by the number of applicants, it actually helps bring the board into the black as to where we're required to be, is what the legislature asks us to do. So, I say all that to say is that we've created a statement for the board, which potentially would allow the board to create these changes in fees via emergency rule. Emergency rule is something that is an exception within the statutory scheme that says we don't have to, is that we can create certain rules for certain reasons, and they will be effective now once they're actually filed at the Secretary of State's office. And they're good for 6 months. It's temporary, 6 months. So, and they will be permanent so long as within that time frame you pass permanent rules through the normal rulemaking process. The statute that I told you earlier regarding increase in fees or creation of fees only become effective July 1 of the following year. There's an exception to that rule. If you pass those rules by emergency rule, then they will be effective on the emergency rule, and they'll be effective on the follow-up rules that follow it. Follow-up rules that follow up. I know that was confusing. I'm going to try not to lose you. On the actual permanent rules, however it is. So if we file, for instance, if we do a normal rulemaking hearing process, and I'm confident we would have that filed by April 1, your increase in fees, the equalization, increase and decrease in fees, July 1, 2017. However, if we, and I believe there is a position to take that we have the authority, you all have the authority to pass them by emergency rules, then those fees could be effective immediately once they're filed at the Secretary of State's office, and then a rulemaking hearing we would have in the future, we're already going to have it anyways, that will make the fees permanent, and they won't need to wait until July 1 of the following year. And that way the board can actually collect fees and start to make its way into actually being a solvent board. So that's the process. And I know that that is confusing. I apologize. I tried to think of it while I was sitting over here as to how I could get that conveyed across to you all in the easiest of ways. And it's not even easy in our office to kind of.
So you're asking us to pass an emergency rulemaking?
Yes, I'm going to ask you all if that you would pass those rules that you've previously authorized. The language you've already authorized is to pass those by emergency rules with the statement that we've developed. I have it here. I'm going to pass it out. But before I pass it out, I wanted to tell you what I was going to do, and then I'll pass it out for you all to look at. And you all could modify the statement or whatnot. But the rules, there's no change in the actual substance of the rules. If there is any typo in any of the rules in here, they would be corrected from what the previous authorization is. We just cut and pasted what your previous authorization on those fee changes were. So I wanted to pass these out to you. And I apologize that we didn't have them on your iPads. But we've been doing this as of last week. We've been developing this theory that we could pass these by emergency rules, and so we've been internally discussing them, and just recently, as late last week, had the authorization that this would be something that we could do. So we didn't get in the iPads in time. I apologize for that. It may not work. Full caveat. The Attorney General's office is the one that has all say on whether or not if they agree with the board that these will actually go through emergency rules, but we're going to try. We think it's worth a try. We think that we have a legal position to take towards the Attorney General's office and say, we believe that the statute allows this board to go ahead and make these fee changes now, not have to wait until July 1 of the next year. And if they disagree, for whatever reasons, we'll communicate that with them, and hopefully they'll see our position. But I just want to call the caveat that it's quite possible that they potentially wouldn't approve that. And we don't know until we give it to them. They won't give us an informal decision on any of this. So let me pass these out for you.
Just on the fee increases?
It's both the increases and the decreases.
Yeah, right. That's what I mean, the change of fees.
Yes, the change.
Surely they will, because it'll help.
Get the money.
Yeah, it creates, yeah.
It's and that's what we're going to go over is the statement of necessity, which is there are very narrow reasons that they allow emergency rules to go through. And one of these reasons that we're looking at that we've written down here is the idea that the board itself, there was a combination of the boards together, and since that time we have not become solvent as a board, and we're required to be solvent in order to do our business, and if we're not, then we can't do our business. So that's kind of our argument here. And the actual statement is what you see on page 1 and page 2. Everything else I gave you was just the rules, because I don't like any board to be attempting to kind of give an authorization with actually the text of the rules being there. That's just not a good practice. My plan was to read this so that you could all kind of digest it together. But it has to do with really the finances of the board that we gathered together. So. And the statement is under Tennessee law, boards and commissions attached to division of regulatory boards and at the Department of Commerce and Insurance are required to collect fees sufficient to cover all costs and expenditures of operating the program. Any entity that fails to collect sufficient fees for 2 consecutive years is required to be reviewed by Sunset at Government Operations Committee pursuant to 429-121. The board is not collecting sufficient fees currently to run and runs the risk of being unable to provide necessary protection of the health, safety, and welfare of the public because of a lack of funds. The board is important for protecting the health, safety, and welfare of the public because it not only licenses and registers practitioners, schools, and shops, but also performs periodic inspections to ensure that services are performed in conditions that do not result in the spread of infectious diseases and that practitioners receive sufficient training prior to practicing. The Board of Barber Examiners, only the Board of Barber Examiners previously is what we're talking about in the past, had fiscal years deficits in 2008, 10, and 2014, And when it was merged with the Tennessee Cosmetology Board, it had a negative reserve balance of $222,191. As such, at the outset of fiscal year 2015-2016, the board had a reserve balance of $394,499, reduced from $810,000 in FY 2012-2013. Further, it's estimated that while current closing is in process, the board will suffer a fiscal year deficit between $150,000 to $200,000 because of yearly collected revenue of early renewals for 2014-2015, as well as reallocations of the division's field enforcement unit, which is heavily relied on by the board to perform shop inspections of more than 10,000 shops regulated by the board across the state. Given the estimated yearly cost of $2.3 million annually for the board, the current estimated fiscal year 2015-2016 reserve balance is only sufficient to cover 8.5% of the board's annual operating costs as budgeted. Further, at this time, the board is anticipated to run a negative fiscal year balance for 2016-2017 as well. This means that a single one-time event or loss of licensees would be expected to result in the board not only suffering a loss of revenue for the fiscal year, but potentially completely depleting the board's budget and creating a liability to the state. As such, given the board's importance to protecting the health, safety, and welfare of the public, and the current expectation that the board will not only suffer a second consecutive fiscal year deficit, but also lack sufficient reserve funds to reasonably expect to continue serving the public in the need for an increase in costs or expenditures, the board has adopted the attached fees as emergency rules upon finding that failing to do so would constitute an imminent threat to the health, safety, welfare of the public. These fees result in the decrease in fees for many barbering practitioners from $75 biannually to $60 biannually, and a small increase in the biannual fees for many cosmetology practitioners from $50 biannually to $60 biannually, which will result in a substantial increase of revenue to the board because of the substantially larger number of cosmetology practitioners, as well as creating fairness for licensees of the board by equalizing fees across the board between the barber and cosmetology professions. So that's a recap of kind of what I explained that we were going to talk about there. Like I said, these numbers, so that you know, were given to us by the accountants here at the department. We did not create those in legal. I just want to let you all know that we did do a yeoman's job of trying to come back and get some of those numbers so that we can make that estimate, because we know that it is an board. And what we're trying to do in your legal division is trying to help the board out if we can. If we can make it so that it's less of a difficult situation financially for the board. If we get 9 months ahead of next July, that's what we intend to do if we can. So, but in order to do so, we would need your board's authorization to do that, and to we would need a roll call vote to approve this statement in these rules. If you all feel that there needs to be an amendment or change to it, that would be up to you all to do.
Any discussion? Any questions? Motion?
Make a motion for a roll call vote on the
Tony, is that
emergency
the correct
funds.
motion you want?
Yes, a roll call vote on the
Emergency
on the statement of
funds, yeah.
necessity for the emergency rules.
Motion, do we have a second? Second. We have a second.
Okay, we will start with Ms. Kelly Barger.
Vote yes to file the rules. I don't know if that's what you're looking for, but yes.
Yes, that's it, you got it, thank you. Ms. Nina Coppinger,
Yes.
Bobby Finger,
Yes.
Mr. Ron Gillihan. Ms. Brenda Graham,
Yes.
Ms. Wyvette Granger,
Yes.
Ms. Patricia Richmond,
Yes.
Ms. Mona Sappenfield,
Yes.
Ms. Amy Tansky,
Yes.
and 9, all yeses. Thank you.
Thank you all. That's all I had, and thank you for listening to me for the earlier part of today. I'll be at y'all's next meeting. I have to leave now, and at the next meeting, I'll probably be introducing you all to a new attorney that we have within our division. So, other than that, unless anybody has any questions for me, I appreciate your time.
Thank you very much.
Thank
We
you.
appreciate you.
Is Since we're on the train of rules, do we want to continue and let Laura finish with the rules before we head back a little bit? Does that sound?
Be fine.
They're so flexible, thank you. So on your iPads, you're on page 230. The first set of rules that Laura's going to review with you are correction, and then we go to the mobile salon piece.
So Tony was talking about the fee changes, and if you'll remember, at the time that we did rules last, we did fee, I divided it up into fees, schools, and shops. All three sets are with the AG's office. It took longer to get through the department than I anticipated, and I apologize, but I am with the AG's office. We're coming to a close with edits, and I just wanted to remind you, I had asked for pre-approval from the board to set rulemaking hearings on already scheduled board meetings. As soon as I get the go-ahead from the AG's office, I'm gonna work on that, setting the rulemaking hearing. I very much anticipate that we can do this far before April 1. I'm hoping sometime, like November. I'm hoping we can do it before Christmas because, like I said, you guys heard Larry Lewis talk about Brad Buchanan. I work with him a lot. He's basically assigned to all COSMO work over at the AG's office, and he's the one going through edits with the board. And the only real issue that he brought up that wasn't just format or word choice, that was substantive, was in our project for the schools. And you can see it's in two places, right? Because it's going to be for the Barber schools and the COSMO school. So on page 234 of your iPads, rule 4 of my form, and then again on page 6 of my form, page 236 of the iPads, one of the things that we talked about schools keeping track of for transfers, cancellations, and refunds is the school shall maintain documentation that the refunds owed to students are issued in a timely manner. I probably should have caught it at the time, but timely manner is very vague, and it was the AG's strong suggestion that passing a rule that's this vague is opening the board up to litigation. So if we want to keep something in there about them documenting when they issue their refunds, I'm going to suggest that the board determine what's a timely manner and then write it in there. So we might want to rely on our school owners.
The feds allow up to 45 days.
45 days. Is that plenty? I think so.
DHEC allows that, and the creditors allow that, and the Department of Ed allows that.
We're consistent. I think that's a really good way to go for both Barber and COSMO, 45 days.
Make a motion to add that to the amendment?
These changes, are we going to need roll call votes on any changes we make here?
No. We'll have to do a roll call vote here in a minute, but I think for this, as long as we all vote in favor, so your suggestion is going to be that timely manner will instead read, the school shall maintain documentation that refunds owed to students are issued in 45 days from the time they are
Within 45 days of the last
Day of attendance.
And then that leads you to, how do you determine last day of attendance? Okay.
Drop date.
I think that is sufficiently clear, within 45 days of the last date of attendance.
Second.
Motion for the amendment. We have a second. Ms. Amy?
Second it. Oh. That was me.
Oh, I'm sorry. Tricia made the motion, Dinah second. All in favor say aye.
Aye.
Opposed say no. Motion carries.
Okay, so if you want to move on to page 241.
So tell me the process with these rules, Laura.
So these rules are rulemaking hearing rules, and right now they are being reviewed by the AG's Office for Constitutionality, which is why I had to come back with this. We're just about done with that. As soon as that happens, I send them over to the Governor's Office or the Secretary of State's office. They sign off on it, and then I file a rulemaking hearing. And I'm going to put it on one of the already scheduled dates.
That's
I
for the
know
public.
that the last rulemaking hearing you had was very long, very contentious. They're not really supposed to be quite that full of amendments, but at that time, you know, it's posted, members of the public can come, they can leave comments, amendments can be made, the board has to respond to all those comments, and then after that, I send it back to the AG's office so they can approve any amendments for constitutionality, and then I file them with the Secretary of State's office. So right now, I'm in the first review with the AG's office, but we're like at the very close. Once I get this change into them, he'll come back and say, yes, approved, go. That's what I'm hoping.
The end result being, it would be, I'm just looking at timing for when they all get adopted. Is that July of next year, that 11 months like Tony was just talking about, or is it sooner than that?
So the July 1 statute for rules going into effect specifically targets fees. So if you raise a fee in your rules, you can only actually in practice raise fees starting July 1st, because that's the beginning of a new fiscal year. So if you don't, and then keep in mind, all of this has to work together. So as you'll remember from the last time we did this, you have to file rules with the Secretary of State's office. I think it's 90 days prior to it going into effect, which means that if you file rules that have a fee change, you have to file them 90 days prior to July 1st. Otherwise, you have to wait a whole calendar year. Everything else will go into effect, but you'll have to wait a whole calendar year for the fee to go into effect, to change.
So the fees are in the emergency filing. These are in a separate filing.
This is from a while back.
Since there are no fees in this document.
No, because if you'll remember, we kind of had a huge project of rules, and I separated them out into fees, schools, and shops, with the intent that the fees would move through quickly, and then they didn't, which is why we are now trying to figure out how to do emergency rules.
Glad you have all this down. I don't envy that.
Okay, so let's move on from schools unless anyone has any more questions. And we're gonna talk about the mobile salon shops. The mobile salon, or the mobile shop rules are in front of you.
Page of
And
them.
I have put them on an emergency rule filing form.
They start on page 241.
I've actually worked on the statement of necessity since these were originally put on your iPad. So I've printed out the first page. I can do it. I've done it all day. I've printed out the first page with the statement on them, because I'm gonna read the statement into the record and ask you guys to adopt them. So let me pass this out and I'll explain the process that I'm trying to go through right here. Mobile Shop Act. The act is going to go into effect on January 1st. And as you've seen, rulemaking takes such a long time, even though I will say that our department is making some changes to make it go faster. We're not going to have rules through rulemaking hearing filed in time for this to go into effect January 1st. So what I'm going to do here today, so these are going to be the things that I'm going to on, is I'm going to read through the statement of necessity. I'm going to ask the board to approve that statement of necessity so I can file the mobile salon rules as emergency rules. Then I want the board to also adopt the language for a rulemaking hearing, and I'm going to start this process simultaneously. So that way the emergency rules go into effect, and in the meantime we're working on the rulemaking hearing to make them permanent. Which is why at the end of the form that's on your iPad, I also have all those accompanying statements that I've had you guys look over for prior rules. The economic impact statement, the regulatory flex analysis. So at the end of today, I'm going to need the board, hopefully, to adopt the language with whatever amendments we're gonna make, adopt this statement of necessity, to file emergency rulemaking, and then adopt the economic impact statement and regulatory flex analysis so that I can file a regular rulemaking hearing. Okay, I'm gonna read this statement into the record since it wasn't originally on the iPads, and then we can start with amendments to the language and I can answer any questions you have. Public Chapter 983 becomes effective on January 1st, 2017. The board is required to license qualified applicants to maintain mobile shops. Without the fees created by the foregoing rules, the department will not be able to inspect these mobile shops. This creates a danger to the health and safety of the public, since what would otherwise appear as a lawfully operated and state-regulated shop will have never been inspected by any state agent. The legislature has effectively required that rules be promulgated in a prescribed amount of time in making Public Chapter 983 effective starting January 1st. I wrote stating instead of starting. Starting January 1st, 2017. Pursuant to Tennessee Code Annotated 45-208, this creates a candidate for emergency rules. Making application to operate a mobile shop is an option created by Public Chapter 983 for already licensed shop owners. Therefore, this enacted regulation on mobile shops does not affect anyone not currently licensed under the shop licensing scheme. As such, these rules will not require anyone to now pay a fee to operate a business model for which they were already operating prior to the enactment of the Public Chapter 983. As I read it, because I really worked on this like last minute, but as I read it into to the record, if the board approves, I would like that to be adopted.
I'll make a motion to approve the statement of necessity.
Second?
We have a motion and a second to approve the statement of necessity. Do we need a roll call?
Yes. We will start with Ms. Kelly Barger,
Yes.
Ms. Nina Coppinger,
Yes.
Mr. Bobby Finger,
Yes.
Mr. Ron Gillihan,
Yes.
Ms. Brenda Graham,
Yes.
Ms. Yvette Granger,
Yes.
Ms. Patricia Richmond,
Yes.
Ms. Mona Sappenfield,
Yes.
and Ms. Amy Tasling.
Yes.
That gives us 9 yeses. Thank you.
Or it should say require, not requires. Did you get that? Okay.
I apologize. I changed stating to starting, require instead of requires, and then I got rid of the extra 4 after fee, pay a fee to operate. I apologize for those mistakes. Okay, we can move on to the language of the rules. So this was sent to you all right after the last meeting with the changes on it. I have left number 19 on there, which is gonna be on page 6 of the rule filing form, but is 36 of your iPads. I'm gonna encourage the board to delete that. This was the part with the GPS. I don't think it's a particularly bad idea. I know other states have utilized it, but I will say that there are some concerns that I have and that the legal department in general has about the kind of situations we're going to get ourselves into requiring GPS. What I do think is helpful about the pop-up inspections, or the lack thereof, which I think was the point of the GPS, is that we are requiring the owner of any brick and mortar shop to disclose the location of the mobile salon, like upon being asked, like at all times. So I think that there are still ways for us to attempt to regulate them. Plus, our inspectors are gonna be trained to stop and inspect anytime they're like driving through their district and they come across one. I'm gonna encourage that. And then on the fees portion, which is just below 19, the numbers that are on there, $200 for the new shop license, $75, $50, those are all the correct numbers. For some reason, I had left in the language of $25, which was really just a stand-in amount when I was drafting originally. And I realized this morning that I had not. I'm gonna ask that we amend those so that the amount reflected is what I had actually typed in with the numbers.
Need a motion for that?
Well, yeah, if you wanna, a motion to delete 19.
Yeah,
and
I'll make
go
a
with the
motion
amendment.
to
But do
delete
you wanna
nine-
have any other discussion or
Oh.
amendments on the language? If you all are fine, then yes, I do need a motion and a roll call vote, since it's a fee change.
I'll make a motion to delete number 19 and then to, on number 6, to change the written dollar amounts to reflect the numerical dollar amounts.
Second?
We have a motion and a second. Is there any other discussion? All those in favor say aye.
Aye.
Motion carries.
Okay. One more vote. I can read it into the record, or we don't have to since you got it ahead of time and it's on your iPads, but since I'm also asking for authority to file a rulemaking hearing form alongside the emergency rules, I have included all of the statements that usually go with rulemaking hearing. Government Joint Operations Committee questions, economic impact statement, and a regulatory flex analysis. If you guys want to take a few minutes to read that over and ask any questions, or if you prefer me to read it into the record, that's up to you entirely.
But we've already seen that, right? We've seen that.
You've not seen this?
We haven't?
No.
No?
Mm-mm.
Oh.
I mean, it was sent out early, but I doubt anyone read it fully on
Just
Wednesday. I just want to make sure everybody takes a chance to read through it and ask me any questions.
Hey, I just see something I need to ask you about. Maybe I'm just not reading it right. Page 250, the fee amounts in there?
$25?
It's 25, 25, 25.
Yeah, that's the same mistake from what was in the, thank you for catching that. That's the same mistake from when I originally drafted these rules, we hadn't decided, because it's kind of more of an administrative question, like, I don't do the accounting, so I just put in a stand-in amount until I fix it, and then I apologize. So I will change that to reflect what's in the rules, and thank you for catching that.
Librarian here.
Different from this morning.
Three things, we approve the economic impact, the rulemaking process, and what else?
So technically, I need the board to adopt the regulatory flex analysis and the economic impact statement. I went ahead and included the government operations committee questions. Technically, I don't think the board has to adopt them, but I wanted them to be in front of you regardless, so you had a chance to review them.
What'd you call them? What kind of questions?
Economic impact statement,
I got that.
the regulatory flex analysis.
Got it.
And then there's the government joint ops committee questions. A lot of the same type of information, just different committees that have to sign requirements. That's it. Guys are, if you have no other questions or adopt those statements, and you can do it all in one motion. I am going to ask that it's a roll call vote, just because it is all attached to a rulemaking project that has a fee. But I'd like you to adopt those statements and approve me to file for a rulemaking hearing form.
Motion to adopt the statements with the only edit we've got is the fees, correct?
Second?
We have a motion and a second. Is there any other discussion? Roll call.
I think last time. Ms. Kelly Barger.
Yes.
I'm out of paper. All right, here we go. Thank you. Ms. Anita is not here. Nina Coppinger?
Yes.
Bobby Finger?
Yes.
Mr. Ron Gilham?
Yes.
Ms. Brenda Graham?
Yes.
Ms. Yvette Granger?
Yes.
Ms. Patricia Richmond?
Yes.
Ms. Mona Sappenfield?
Yes.
And Ms. Amy Tansley?
Yes.
All 9 votes yes. Thank you.
Rulemaking.
Okay, we're going to find our page.
Thank you, Laura.
Thank you.
I know it gets complicated. We're in the process ourselves trying to document all of the specific steps that are found all the different places, but and like Tony said, with the other emergency rules, there is no guarantee that the AG will approve this emergency rule. I plan on filing emergency rules and a rulemaking hearing form simultaneously, so either way, we'll get there.
So what happens if they don't approve them? I mean, the mobile salons are going live January
Not really
1st.
sure.
Okay,
I will update you when we know what happens.
fair enough.
Okay, so we're back finishing up on the miscellaneous chunk of our meeting. On page 223, we have, this is an informational piece more than anything else. This is the Institution School of Cosmetology. They are requesting approval for nighttime hours as well as separate curriculum for instructor, manicurist, and natural hairstylist. Because the school is already licensed as a full cosmetology school, it has already been inspected. And so the approval of the floor space has already taken place. They, in essence, don't really have to be approved for this change. But before you is the first letter that Dr. Joyner presented, and then his assistant just giving us more information. I let them know that at this particular time, because it's a cosmetology school and their renewals are open, cosmetology schools now, for the first time, and barbering schools are doing the same thing. They are all renewing online. It has been fantastic. Whereas the licenses used to go out the last week in August, first week in September, we were manually tracking. The minute they renew, the license goes out the door. and we've got all of their responses electronically. They're responding who the instructors are, the license number for the instructors, the hours of operations, and so forth. So if a school changed slightly, they would be able to tell us, now we're closed Mondays, but here are hours of operation. And there's nothing that says we have to review and reapprove those things. So this school is going to take advantage of that. This is more just really an informational piece. There's nothing that needs to go out to them. It's one of our newer schools, and they're doing well. They wanted to add some other curriculum. So, yeah, I think that's a great thing. Next is also an informational piece. Paul Mitchell was going to attempt to have someone here. It's a possibility they were here with all the people earlier. Hopefully they would have said something to us. They knew they didn't have to come. This is the schools out of Murfreesboro and Knoxville campuses. They are adding the makeup curriculum. If the board recalls, they had a very extensive presentation on what all would be covered. The email between Kevin Johnson and myself is on page 229, basically explaining that they're going to add 95 hours of specific certification information on makeup. So a cosmetologist early on, as they sign the contract, can state that they want to do the emphasis on makeup and take the extra hours. They don't have to, obviously, and we won't be certifying those hours, but they've got that path. They're seeing a lot of need for the additional makeup. So that is that piece for you.
They give them like a certificate or something?
They do. They do. And they've got a real good game plan with those hours and work-related things, so. Okay, then I'm skipping over the rules because the board will be happy to know we've finished those. We are on to your iPads on page 254. And before we go on to the consent orders, I'm going to turn it over to Ms. Coppinger to kind of fill us in on the reciprocity so we can vote all that in.
Okay, we had 22 cases of reciprocity that came before us. We voted that 10 take both exams, 1 take the practical exam only, 9 we granted reciprocity, and 2 we denied. And the reason we denied both of them pretty much was false information was given by the applicant, and et cetera. So we just needed a motion to adopt that or accept that.
I'll make a motion to accept
Second.
the committee report.
We have a motion and a second to accept the committee report. All in favor, say aye.
Aye.
Motion carries.
Thank you.
Can I just ask a question? We had a woman who applied to come work for us, and through the interview process came back to us and said, oh, she'd been working in the Nashville area for a while, that had applied for reciprocity but had never received her license, and she thought the process was done, and had basically been working then without a license. I don't know for how long, not for us, for another. If she comes for reciprocity, is she allowed, how would that work? If you've applied but you've not received it, do you have to reapply?
Within 6 months, the application becomes old, if you will. The money doesn't go away. We always try to be courteous and move the money over. We haven't necessarily used it all, so that's not the issue. It's that the information is likely changed. You've either moved, which is what happens a lot with our reciprocal applicants. And so we ask for a new application, that's all. I would say hopefully 9+ of the 10 applicants contact us and say, I haven't heard back what's going on. The issue with reciprocity is because they've moved, we will send letters saying this is missing. We try to communicate with email, but the problem with email is it goes to the junk mail. So many of our licensees that aren't into looking at those processes kind of forget because the move has gotten in the way and they start doing things. So we hear it, you know, I didn't check back, it's been 5 months, 6 months, we'll say, we sent you an email 6 months ago saying you were missing XYZ. One of the main factors they're missing is that eligibility form, and they just don't realize. The other factor many times is, similar to our applicant from Maryland who had a reciprocity license from North Carolina that was fraudulent, all of a sudden when we get the license, we see that there's another license somewhere there. We can't approve it without seeing that other one. So we say, we notice that you're licensed in Virginia, or this certification is saying something. And again, if they don't follow through, we don't do anything else. It expires. So, but if she applied right now, and it came up that she was working unlicensed, I'd have to present her to the board. If we don't know that she's working, we just treat it like any other reciprocity application and move on.
I didn't hire her, for the
Yeah.
record. I'm not in trouble. I just didn't know what to tell her.
And for the board to know, for those that are school owners in particular, your applicants now can go to core.tn.gov and you apply for a new license. You can apply for a new school license, a new shop license, a new personal license. That's your individual licensees as well as reciprocity. So when you hear someone just moved here from New York and they're don't even go to the application. Hit the application, reciprocity application, because then we have it that night. We still don't have the other states' documents, right? So we're waiting on that piece. But the text online says, please remember to contact any and all states you've ever been licensed in. Think of the name issue. The name issue is a big deal. If you changed your last name, we don't find you. It just all of a sudden comes here. And because we have 58,000 licensees, then it's just really hard to tell who that ties to. So, but they can do that online. That is going to soon help us a lot. We're still in that learning curve. But yeah, just apply.
Other states sometimes also charge them
Correct.
a fee for certification of.
Yeah. We actually have an applicant then, to avoid the fee to get certification, created his own certification. And of course, tripled his time because I had to deny. It was just, had he paid the fee and we'd gotten it, because he was legitimately licensed, he just didn't want to pay that $50, $100, whatever it was. And it was obvious the document was false and just made no sense. So, anyway, okay, next I'll turn it over to Mr. Gillihan. I think we ended up doing the legal committee, if we can get a vote on the 82 cases that were heard. Amy?
I think the only thing we wanted to talk about were those parties.
We had two cases where one was a salon, I guess, that was doing little girls' makeup hair parties with nail painting and whatnot. The owner, of course, was a licensed person, but she
was employing some others who were not licensed.
employing some other staff without license to work on the children. And I think her response was that she thought that would fall under pageants and things like that. So,
Other business.
can you clarify
Yeah,
for
I
me?
can.
You've
So
got it right in front of you.
It was just interesting because I haven't seen this at all in the twice on this legal report, but so there's two cases. One, and the business model is that people can hire them to have birthday parties for little girls. So like think 5, 6, 7, 8, 9, whatever. They'll do
At their homes, right? At the homes,
at
not
their
in the
homes,
salon.
yeah. And they'll do hair and makeup and crafts and nails, and then they have runways and they dress up and they take pictures. I mean, the pictures are so cute, but I think so especially with the company that's completely unlicensed, is they wrote back and said, well, this is just for the photos. This isn't like legitimate salon services. But I think what we decided at the end of the day is unlicensed people can run the parties. They can they can help with the dress up and the crafts and all of that. But even if it is for the pageantry, if you're working on hair, if you're painting nails, anything like that, it needs to be licensed. And I think we decided to send letters of instruction and letters of warning to these people.
Have a shop in their home? I mean, how did anybody know they were doing it in their home?
Facebook, I guess. People filed complaints. Other licensees, frankly, see this happening, see that it's not licensed people, and they file complaints. And then that's where a lot of the consumer complaints come from, is from other licensees. There was a few other amendments. Mostly it was just for consistency purposes, but those were the only two that we had a real long discussion about.
Does anybody have any questions about party licensing stuff?
I think we decided that if they go into people's homes, since it is, I mean, it's
Are they
definitely.
selling a product or are they just selling services?
They're just selling services, and I think that after like reading through their business, and I mean, a lot of them were advertising on Facebook and other other online profiles, Twitter, what have you. It really is more of, I think it falls into the entertainment exception. They're coming into homes and setting up runways and photo booths, and it's a party. And the little girls are dressed up like princesses, and they take pictures and all this stuff. So I think that they're okay not working in a licensed salon, because I think that falls into that exemption, but the people actually offering those services that we decided, or the board decided, needed to be licensed. Big discussion this morning.
You have to have a manicure, a licensed manicurist paint nails in a house or at a party? We're ready.
How would that differ from like the beauty control Mary Kay home parties where they're actually doing facials and makeup?
Well, because in Mary Kay, they're selling Mary Kay product. So the idea is that when you get your makeup done by a Mary Kay rep, they're just demoing their product in the hopes that you're going to buy their product. And the statute has always exempted those people. Here, nobody's buying nail polish or any sort of makeup. It's all about dressing up and having the party.
My teenage daughter's had a nice business being the character from Frozen for those parties. She does a lot of those. Doesn't do hair and nails, but she does do the characters. So we need a motion, I guess, to accept the legal report.
Make a motion to accept the legal report.
Second.
We have a motion and a second. All in favor, say aye.
Aye.
Motion carries.
Wonderful. Okay, next you have on your iPads, this is the consent orders for June and July, given that we did not have a July meeting. The total amount of $42,300 was collected for civil penalties from consent orders. I would need a motion to accept these.
Motion to accept the consent orders?
Accept, or
Second.
We have a motion and a second to accept. All in favor, say aye.
Aye.
Motion carries.
I'm at the wrong board.
The following two pages are for the agreed orders. These two are for June and July for a total of $18,700, and I will need a motion for that.
Make a motion to accept.
Second?
We have a motion and a second to accept. All in favor, say aye.
Aye.
Motion carries.
There are no letters of warning for these 2 months, so we are on to new business, and I promise I'm going to keep it short and simple. I emailed everyone the 2017 meeting dates. Hopefully everyone had a chance to look at them. We've been confirmed to be able to use this room through all of 2017. The date that I know, I'm sticking to what is the process for the board. We have 9 scheduled meetings. We skipped January, July, and September. Please make sure that these are marked on your calendar. They are not always the first Monday of the month, so I want to make sure that everybody remembers the right date. If you've got any conflicts that you think would be reoccurring enough for us to think about changing them, let me know. And then the one date I do want us to talk about is that February Super Bowl. I did check the date this time.
I know.
So if we do the 13th, we're skipping the Super Bowl Sunday, or we go backwards. I just wanted to pose that idea. And I know normally we don't have January because of the holidays and everything else, but if we go to the January 30th, we'll have more of a stretch meeting everybody's business and not be so swamped. If we have it on the 13th, we're back less than 3 weeks later.
I like the 30th, January 30th.
Okay. Everyone in agreement with that? Yes. Okay. It'll be a little bit different, but again, will be posted on the website. Everyone will be aware. I will make sure and at the October meeting, hand everybody paper. So we're good, and then they'll be published on the website for October. I don't know that the continuing education groups will be ready in October to present. They probably will wait till November, but I'm going to reach out to all the sessions that we've held and see if they are ready to present their dates. The last piece that I wanted to talk about, and Tony kind of introduced it, is the financial piece. I had hoped that we would have final numbers for this fiscal year. I had been looking at the possibility of us ending in the red, just a little bit of everything. A big piece is the previous year when we rolled CORE, which is the new computer system, we sent out a lot of early renewals. It probably added over $150,000 of income to the previous year, which means we were short that much income this year. The other pieces is our legal cost has gone out a lot, like most of our chargeback costs that we have that we share. Because we have so many licensees, we have so many complaints, we're kind of hit from both those angles distributing the cost. We've had a lot of cases in litigation, the school that we denied today. Those cost us a lot of money no matter what we do. So because I don't have final figures, I didn't present them to you. At the October meeting, we will get that final number. And yes, it will be in the red. Last I heard, it's gonna be less than 30,000 or around 30,000 in the red, but it's still where we wouldn't wanna be. So Tony's approach and the thought of doing the emergency rules will help us get comfortable again and get in a place where we're meeting all of our numbers.
I just want to ask one question, and it's not pertaining to that, but how are we looking with our apprentice program across the state?
The apprentice is still only cosmetology, right? The
Right,
barber
right.
rules will be finalized, and as soon as they are, they'll become part of it. But what we've done with PSI is those applicants that are already testing PSI after they take the theory exam blocks them for the practical. That gives us some control to see how many are going through, and as of the end of June, 5 apprentice students were just about ready to take their practical. And so I believe we've licensed 1 or 2 at the most. The theory exams have still, surprisingly enough, they've still not passed it. And again, I was only looking at the first 5. 3 of those first 5 failed the theory the first time, 2 passed it the first time. Some of that has to do with the language. And the books aren't written as well, maybe, or translated as perfectly as they could into the language. And the other piece I think that our language is struggling a little bit with is at the schools, they're still taking the material in English, and then they're testing in their own language, which definitely helps, but there's still a bit of a disconnect.
Books have been the biggest problems for them. It's just not out there.
They're just not great, right, in the other
Right.
languages? Yeah. So, that's kind of the update so far on it. And in Ms. Turner's case, she'll be submitting her first group to test here soon.
I had a question. I had a physician assistant wanting to know about doing eyelash extensions. She has to be an esthetician to do that, even with her degree.
Cosmetologist or a master barber. Barbers do eyelashes too.
But she has her medical aesthetics or whatever under somebody. So she has to be licensed, okay.
I know at one point, before the boards were merged, I presented that request. I don't know if Ms. Sappenfield was on the board during that time or not, but it was denied if they had a medical license to do the eyelash extensions, because that's specifically in the discipline that we do. It has to do with beautification, not anything medical. It doesn't mean that she couldn't apply, question it again, but. And that is all that I have. If the board has anything else.
Oh, please, come on, let's throw some. Anybody? Since we're finishing on new business here, I want to take just a moment, if you don't mind. It's not on the agenda, but if you'll indulge me, could I make a quick presentation about a program change I'd like to think about? Okay. I'm going to come back here so there won't be any questions about the chair.
Good
Trying
afternoon.
so hard.
Since we've had such a light day today, I had mentioned to Roxanne a few times before, earlier in the year, my school has been working on a little project, and I think we're about ready to roll it out. It goes hand in hand with some of the other things that have been coming in front of the board, in particular today. We had somebody here. We have designed a electronic and online program for our theory class, okay? I guess I'm going to ask you folks for permission to add the possibility of teaching a theory class through an online lesson. It is almost identical to what you've seen in other programs. We're using Adobe Foundation. Some of the things that the program we use will do, very simply, of course, everybody has to log in. Everybody has to sign. Sorry, we will have a video system so that we can actually see all of the people who are sitting there in front of us. So if you're a student, we get to see your smiling face on our screens as well. See us, there's that component. Within our system, every few minutes, there will be some sort of a pop-up for a question to gauge how well you are actually engaged in the process, so you're not watching TV out of the corner of your eye. And then, of course, it'll generate reports and things like that to show us graphs on how engaged you are. I know that there's nobody else in Tennessee that's doing this, and it's a stretch for where we're at. I hesitate to even bring it up today because I don't have a video presentation to show you today. But since we're not going to have a meeting in September, I think it's something that I bring up to you and see if you have any questions about it or how you even feel about it.
Great to me. Yeah. I mean, and you want your school to be successful and to be run well, so you're going to make sure, I mean, you won't know till you try it, but it sounds like it's something that would be successful.
I'll be happy to give reports going forward and kind of let you guys know how it works out. I anticipate that we would do it for a short time at least, only encapsulating the students that we have and just roll it out small and let them see how it's going to work within their curriculum. I'm not trying to say that this is going to take over a program and it's just for the theory portion. So.
Come in and get their practical.
Oh, absolutely. Nothing else changes. One of the components in the BARBER law, of course, is that the student has to attend at least 1 hour of theory class every day of attendance. And so I'm just looking at another option to allow some of these students to be able to have a little bit greater flexibility with that, still meet the requirement. Okay.
Want to put him on a 1-year probation?
Yes.
Thanks, so.
Sign consent order, please.
Please.
Sounds great to me.
So I guess, is that all I need?
I mean, from my experience, the online stuff, I don't know if I mentioned this last meeting, but several of my employees have their instructor's license, and when I mentioned the online CEUs, I mean, they literally started jumping up and down.
It's
They
exciting.
were so excited. So I think,
I think a lot of it's going that way. I mean, Pivot Point has the whole theory thing online. They can follow along and.
So we have nothing that says that you would need to apply. It's a substantive change to the hours of operation and the material. But if the book is the same.
Same curriculum, same
actually,
course,
right.
same instructor.
Unless you see otherwise, I don't think the board has to consider anything. As a matter of fact, the TCAT schools have a lot of almost all their makeup hour, if someone misses, is on these online chapters. And so they've incorporated the Milady and Pivot Point's online piece for a bit. So I think if the board's okay with not seeing it and releasing it that way, there's no big change necessarily.
No double dipping on the hours and things like that.
I will let the board know, since we touched on it, I did have one of the sessions not happy at all that the board approved the online curriculum for the continuing education, and I said that's just, part of free business and
Well, yeah.
being creative.
Not just in our industry, in every.
In every industry, that's correct. So we don't have anyone from the board attending the online session. Ms. Richmond has attended herself for her own hours. So I want, we don't have to do it immediately, but I do want the board to consider if we continue them for 2017, then someone from the board will need to to give feedback to the board, and taking it as a board member, probably take the 16 hours.
I liked it. I liked it. I mean, it was just more convenient, to get away from the school and then having to go to one for the board and then having to do another one in the same year. That's like 2, So really, I loved it. And I've got some of my instructors are doing it, and some of them chose to go to TSU. So it's totally whatever anybody wants to do.
Well, I think for this year, without a doubt, with her feedback having taken it, we're fine. And then we'll just, when we vote for next year who attends, we'll make sure that the board picks a board member and we've got some feedback. But I think what we've seen and read so far from, she submitted May dates and June, the comments were good.
Thank you, by the way. Is there anything else to come before the board? In that case, can I have a motion?
Make a motion to adjourn, please.
Can I have a second? Miss Brenda?
Brenda.
All in favor, say aye.
Aye.
We're adjourned.
Thank